Good evening, everyone, and welcome to the September 21st, 2020 legislative meeting of the Anne Arundel County Council is now in session. Madam Secretary, please call the roll.
Ms. Fiedler,
Present.
Ms. Rodvian,
Present.
Ms. Hare,
Present.
Ms. Lacey,
Present.
Mr. Volkey,
Present.
Mr. Pruski,
Here.
Ms. Pickard.
Present.
Madam Auditor.
Present.
Okay. And Madam Legislative Attorney. Ms. Schuett, are you here?
I'm present. Thank you.
Thank you. Madam Chair, all are present.
Thank you. Please pause for the invocation and following with the Pledge of Allegiance. Ms. Fiedler will lead.
Thank you. If everyone could please join me for a moment of prayer and pray in a manner that is in line with your personal faith. We are thankful for this day that you have given us, for its blessings, its opportunities, its challenges. May we appreciate and use each day that comes to us. We pray for strength and guidance for each day as it comes, for each day's duties, for each day's problems. May we be challenged to give our best always, and may we be assured of your presence with us. Amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Madam Secretary, please read the Open Meetings Act statement.
The county attorney has asked that I read the following statement. The Maryland Open Meetings Act, a state law, requires public meetings to be open to the public and to be held in places reasonably accessible to individuals who would like to attend these meetings. General Provisions, Article 3102C. The virtual format of this meeting of the County Council is due to the COVID-19 emergency and is necessary in light of the serious health risks associated with public gatherings, as well as the governor's various executive orders limiting public gatherings. While a virtual meeting of this type was not envisioned by the Open Meetings Act, steps have been taken to ensure that this virtual meeting includes alternate accessibility features that the Open Meetings Act Compliance Board and the courts have reviewed and approved, such as having a call-in phone number that allows anyone with a telephone and to call and listen to the meeting, broadcasting the meeting with video and audio on cable TV and on the web, and allowing written public comments to the legislation be filed with the clerk and considered by the council. The County Office of Law has opined that the public access provided by this technology makes this virtual meeting reasonably accessible to the public and therefore complies with the Open Meetings Act.
Thank you. Madam Secretary, please read the ethics statement.
The Ethics Commission has asked that I advise you that under certain circumstances, members of the public may qualify as lobbyists when they testify before the County Council. If so, the law requires that certain information be filed with the Ethics Commission. The chairman of the Ethics Commission has asked that those who wish to testify in any form review the general information on lobbying sheet located on the ethics website under forms and publications. If there are any questions about lobbying requirements, please contact the Ethics Commission at 410-222-4413.
Thank you. Because this is a virtual meeting, we cannot be physically located in Annapolis, the county seat, and we cannot provide reasonable seating facilities for the news media or the public. May I have a motion to suspend rules 3-103, 3-105, and 3-106?
Lacey, so moved.
May I have a second?
Ms. Rodvian, I think you were seconding, but you've mute.
Sorry, Rodvian second. Thank you.
Madam Secretary, please call the roll on the motion to suspend rules 3-103, 3-105, and 3-106.
Ms. Fiedler,
Aye.
Ms. Rodvian,
Aye.
Ms. Hare,
Aye.
Ms. Lacy,
Aye.
Mr. Volkey,
Nay.
Mr. Pruski,
Aye.
Ms. Pickard.
Aye.
6 in the affirmative, 1 in the negative. The motion to suspend rules 3-103, 3-105, and 3-106 is passed.
Thank you. We are very pleased to have members of the public signed up to testify directly before the County Council this evening. Testimony submitted through our online tool is also being received. It has been received by all council members and is posted online for the public to view. And counts of the submissions will be announced at the appropriate time. At this time, we're going to have a quick presentation. Ms. Laura Corby, our Assistant Administrative Officer, is going to take us through instructions on using Zoom for public testimony. Ms. Corby?
Hi, good evening. This is Laura Corby. I'm the Assistant Administrative Officer to the County Council, and I'm going to go through this rather quickly for some of the members of the public that have been participating and so that the council may help people be more successful in their testimony. The first tip we have is when you join the meeting, look for opportunities to test your speaker and your microphone. You can see that in a prompt when you join the meeting. You can also do that through your audio settings. It's a good way to make sure that you're ready to speak and that your microphone is working. The second tip, attendees who are in our virtual waiting room will see on the screen a bar similar to this. Chat and question and answer will not be seen. It's disabled for our meetings. However, that audio settings and the small arrow that appears next to that is a great way to also check your microphone and other audio settings to make sure that you're ready to go. The final tip that I think is probably the most useful is when it is your turn to speak, you have to wait for council staff to give you permission to talk before you can unmute yourself and then testify. It can be a lot and it moves rather quickly. So once you're allowed to talk, you will want to look for this notification that you see here, and you're going to want to unmute yourself. Then you should be able to talk and say your name. So hopefully that helps people be more successful in their testimony before the County Council. Thank you very much.
Thank you, Ms. Corby. I think that is helpful. We will now open our invitation to audience. Madam Secretary, do we have any comments or communications on any subject not included in the printed agenda received from members of the public?
Madam Chair, we have received 4 submissions of written testimony, which was shared with the council and posted to the council website.
Thank you. We did not have anyone register to address the council during this portion of the meeting. Invitation to audience is now closed. Is there any item any council member would like to place on the agenda at this time? Mr.
Madam Chair, thank you. Nathan Volkey, District 3. Madam Chair, I wanted to follow up on the request that I had made on, I believe it was the 15th of September by email, that we have Dr. Kalyan Raman, the health officer for Anne Arundel County, attend this meeting so that we could continue the discussion from the work session. As we'd mentioned then, it was a continuing conversation, and I was hopeful that we could have him here this evening. So I wanted to see if we could add that to the agenda if he's available, because I'd sent that request and I hadn't heard back. So
I believe Dr. Kalyan Raman will be here to address potential resolutions that are being introduced this evening. He is not here to, he's not on the agenda or prepared to speak after our 1.5-hour work session where he addressed our questions.
okay, so Madam Chair, Nathan Volkey, District 3 again, then I would ask that we add to the agenda, I guess at the end is the appropriate place, but add to the agenda an opportunity for us to have a discussion with Dr. Kalyan Raman about the status of COVID-19 regulations in the county, as well as reopening decisions and what was the subject of the most recent work group meeting, I think this week, or last week, excuse me, last week.
Madam Chair,
Yes,
I'd
ma'am.
like to double check with our parliamentarian. I think we discussed this last time, whether it's appropriate that there should be a vote.
Can you give me a moment to find the rule again? I found it once before. So the rule is 4-101. The subject matter of the rule is the agenda. And section B says opening and closing of agenda. The agenda shall remain open until the meeting is called to order. At the call of announcement of items not appearing on the agenda, each county council member shall have the right to place on the agenda any bill or resolution to be introduced or any item of business. Once the meeting has been called to order, the agenda is closed and may not be reopened for additions except by suspension of these rules. So it does address something going onto the agenda that relates to a bill or resolution or to any item of business. And there's no discussion about a vote on it either.
Mr. Volkey. You're muted, sir.
Oh, sorry. Thank you. Nathan Volkey, District 3. Thank you, Madam Chair. Ms. Schuett, quick question. So by virtue of the way the rule is written, I actually interpreted that we would need a suspension of the rules because the agenda is set. And so to add something to the agenda, we would need a 5-member vote, I believe, to add something to the agenda. Is that correct? Do you read it that way too?
I think it's a little bit ambiguous because it seems to say that the agenda is closed the minute the meeting is called to order, and the meeting has been called to order. But on the other hand, it says at the call of announcement of items not appearing on the agenda, which has that just occurred?
That did. Yes, Nathan Volkey again, District 3. Apologies.
Right. So if this is the part of the agenda which is called announcement of items not appearing on the agenda, each council member shall have the right to place anything on the record, whether it relates to a bill or a resolution or any item of business. So I think that's contradictory. I don't know how the agenda can be closed and then yet somehow have another item put on the agenda.
Might I make a suggestion that we possibly hold this thought while Robert's rules, maybe Ms. Hewitt could double check Robert's rules?
My concern with adding something to the agenda, such as Dr. Kalyana Raman coming to address the council and therefore the public, is that the public has not been informed of this being added to the agenda and would not possibly know it is happening this evening. Therefore, the conversation, I mean, this is what we talked about last time we went through this. That's my concern.
Madam Chair, I can simply address it by saying historically, items not appearing on the agenda has been used basically specifically for the introduction of a bill or resolution that was not ready in time to be placed on the agenda.
Mm-hmm.
So it could be introduced so it could come back in a month.
Mm-hmm.
It's also periodically been used for a quick announcement.
Yes,
which
ma'am.
is actually more better placed at the end of the meeting at other business, but it has been used for that too. Those are historically the uses for it.
Thank you. Ms. Hare.
Thank you, Madam Chair. Jessica Hare, District 7. What then would be, Madam Secretary, or perhaps Ms. Schuett could help us out then, what would be the appropriate way to put this on the agenda for the next meeting? Because it sounds like Councilman Volkey had actually asked for this to be on the agenda in advance and asked for Dr. K to be here. So what, if we can't do it at this point in time and he tried in advance, what would be the appropriate way to do it so that we make sure we do it properly in the future?
Well, this is Allison Pickard, Chair, District 2. It needs to be, there's a reminder to the council that while we can request administration representation at our meeting, they don't have to come. We don't get to direct the administration in that way. That is not part of our purview. We spent considerable time of this council's time and also Dr. Kalyana Raman's time on last Tuesday, September 15th, addressing the issues. We can consider inviting him at a further meeting in the future, but we'll take that up maybe after we get through today's agenda. Mr. Volkey.
Thank you, Madam Chair. My understanding of how Robert's Rules works, and having reviewed our own rules and having previously once run meetings before and having to deal with these issues, is that typically the chair sets the agenda, which is why I made the request to the chair to set the agenda. However, as a protection for the other members, that's why typically there is a provision that allows that upon a suspension of the rules, that then the agenda can be amended. And I believe that's effectively what Rule 4-101 allows under our council rules, so that we can make requests and the chair can set the agenda. But if a member chooses to add something and asks that it be put onto the agenda, at that point, other members would need to weigh in and say that they too would like to hear about that issue. So that's my understanding of how this process works and the reasons for why it's set up the way it is. I have my copy of Robert's Rules sitting across the room, so I can go get it. But that's my understanding of how it works, which is why I would ask that this be added to the agenda. And I believe that then requires a vote. And with 5 affirmative votes, we can suspend the rules to add something to the agenda now that it's set. Thank you.
Madam Chair,
Ms. Schuett.
I can understand that particular interpretation of it. I find confusing, however, that the rule says that at the call of the announcement of items not appearing on the agenda, each county council member shall have the right to put something on the agenda, and then goes on to talk about how nonetheless the agenda is closed after the meeting has been called to order, and then you have to do a suspension of the rule. So I guess the bottom line is, I think our rule is not well written and difficult to understand what the meaning is. But it does cover this subject matter, so I don't think Robert's Rules would supplement this in any way. So there is my very ambiguous and unhelpful interpretation of the rule.
Mr.
Thank you. Point of order, Madam Chair. Nathan Volkey, District 3. So then either, it sounds like under Ms. Schuett's interpretation as the parliamentarian, and she is the ultimate arbiter here, it simply goes on the agenda without a vote. Is that correct?
That's only correct if you don't include the last sentence, which says that to put anything on the agenda after the meeting has been called to order, you need to suspend the rules. So that's why I'm saying I can agree with your interpretation, because there's no point to that sentence if you have the right to put something on the agenda. You don't need to suspend the rules if you have the right. So I think the more specific of having to suspend the rules would likely apply.
Madam Chair.
Mr. Volkey.
Thank you, Madam Chair. Nathan Volkey, District 3. So then in that event, and given Ms. Schuett's interpretation, I would request that we take a vote on the suspension of the rules as to whether to add this item to the agenda or not.
Okay, so specifically, Mr. Volkey, you want to make a motion to suspend the rules to add an item to the agenda.
That is correct. Nathan Volkey, District 3. Yes. And the item to be added to the agenda, specifically from my email on September the 15th, was that we discuss the decision to remain in stage 2 and not to move to stage 3, and to address the current state of COVID-19 and the related regulations in the county.
So there's a motion to suspend the rules to add, to request Dr. Kalyaraman join us at the end of the meeting. Is there a second?
Fair, second.
Madam Secretary, please call the roll on the motion to suspend the rules to add a request to bring Dr. Kalyaraman, if he is available, to the end of the meeting for a discussion about COVID-19 regulations.
Madam Chair.
Mr. Pruski.
Thank you. I do have a right, and I would ask, I need to clearly understand this motion. So obviously there was an email request to the chair, but was Dr. K informed that he will be speaking tonight? Did the councilman that's asking for this motion reach out to him to be prepared to discuss the topic at hand? I just want to make sure, because certainly if we're having a presentation or a discussion, anyone should be given the right to be prepared and answer questions. So I just want to ask what communication occurred between the motion being made and also the presenter. Thank you.
Mr. Volkey.
Thank you, Madam Chair. Nathan Volkey, District 3. Appreciate the question, Councilman Pruski. Specifically on the 15th of September, I emailed Council Chair Allison Pickard, Ms. Gray, who is our administrative officer, Ms. Corby, who is our assistant administrative officer, Mr. Barron, who is our government relations liaison between the county execs administration, of which Dr. Kalyan Raman is a part, as well as Mr. Trumbauer, who is the deputy chief administrative officer at this time, but who previously served in a policy and community role. In that, I specifically asked that to follow up on the work session, that we continue to receive updates and ask questions about COVID-19. This is a formal request that the chair of the county council, one, invite Dr. Kalyan Raman, health officer for Anne Arundel County, to attend the September 21, 2020 meeting of the county council, as well as any other department heads necessary to respond to the below items. And two, items to be added to the council's agenda for September 21, 2020 meeting to address the decision to remain in stage 2 and not to move to stage 3, and to address the current state of COVID-19 and the related regulations in the county. So yes, I did apprise the administration as well as all the council staff of the request that Dr. Kalyan Raman attend. Also, this was discussed in our September 15th work session, wherein I asked what the next time would be when we would have Dr. Kalyan Raman in front of us. And I could not get a commitment either from him or the administration at that point as to the next time, other than to hear that the county executive is hosting these virtual town halls. And so we could watch those and the public could see what was going on there, because they happen on a weekly basis. Nice plug for them. So that is what I informed the administration of my request. And I have to believe that Mr. Barron, as it is part of his job as the liaison between the council and the administration, would have relayed that request to Dr. Kalyan Raman. Thank you.
Mr. Brusky.
Thank you, Madam Chair. Councilman Andrew Pruski. I'd like to hear from the administration on this in terms of response, if they have any, in regards to preparation, other things. I certainly, would like to have be open to council members having discussions, but in terms of being prepared, and we did have an hour and a half discussion at the work session, which was on video, but I would like to hear from the administration if possible. Thank you.
Is Mr. Barron prepared to answer that question of Mr. Pruski?
Madam Chair?
Yes, ma'am.
My apologies. I'm actually double checking, and there is no debate on this motion.
Okay, let's proceed with it.
Sorry.
That's okay. Let's proceed with the vote. Thank you.
Okay, I believe we have a motion and a second, and I'm hoping I have this motion correct. I believe it is a motion to suspend the rules to add a discussion with Dr. Kalyan Raman regarding COVID-related issues to the agenda at the end of the meeting. Is that motion correct?
That's general enough. Yes, Nathan Volkey, District 3.
Okay, Madam Chair, then at this time, I'm assuming it would be appropriate for me to call the roll.
Please call the roll.
Ms. Fiedler.
Aye.
Ms. Rodvian.
Nay.
Ms. Hare.
Aye.
Ms. Lacey.
Nay.
Mr. Volkey.
Aye.
Mr. Pruski.
I'd like to explain my vote. I certainly appreciate that there's no debate. I think that's something we need to change in our rules as we go forward to discuss any types of motions. But I am going to vote no because of the issues that I've raised and some other concerns. Thank you.
Ms. Pickard.
Nay.
3 in the affirmative, 4 in the negative. The motion to suspend the rules to add discussion with Dr. Kalyan Raman regarding COVID-related issues at the end of the meeting is defeated.
May I have a motion that the partial reading of any bill, resolution, amendment to a bill or resolution, or minutes constitutes the reading of the whole?
Councilwoman Rodvian, District 6, so moved.
May I have a second?
Councilman Pruski, second.
All in favor? Aye.
Aye.
Any opposed? The motion carries. Madam Secretary, please read the minutes of the September 8th, 2020 meeting.
The meeting was called to order by Chairman Allison Pickard at 6 p.m. Mr. Pruski gave the invocation, followed by Ms. Fiedler leading the Pledge of Allegiance. The meeting was held remotely via Zoom webinar, beginning with roll call of all present.
May I have a motion to approve the minutes of September 8th, 2020?
Councilman Rodvian, District 6, so moved.
May I have a second?
Councilman Pruski, second.
All in favor?
Aye.
Aye.
Opposed? The motion carries. The minutes of September 8th, 2020 stand approved as read. Madam Secretary, please read the titles of any bills to be introduced this evening.
Bill number 7520, an ordinance concerning conveyance of surplus property, unimproved county-owned property near Furnace Branch Road in Glen Burnie, Maryland. Bill number 7620, an ordinance concerning subdivision and development, adequate public school facilities, school utilization chart. Bill number 7720, an ordinance concerning planning and development, master plan for water supply and sewerage systems. Bill number 7820, an ordinance concerning subdivision and development, fees and security, use of development impact fee funds. Bill number 7920, an ordinance concerning public works, utilities, extension of public water and wastewater systems. Bill number 8020, an ordinance concerning public works, utilities, assessment, water and wastewater facilities. Bill number 8120, an ordinance concerning zoning, home occupations, cottage food business. Bill number 8220, an ordinance concerning zoning, requirements for special exception uses, indoor rifle, pistol, skeet, and archery ranges. Bill number 8320, an emergency ordinance concerning proclamation of civil emergency in Anne Arundel County, termination.
Sorry, I'm muted. Madam Secretary, please read the titles of any resolutions to be introduced this evening.
Resolution number 3620, resolution concerning approving the determination of certain unimproved county-owned property being part of Old Admiral Court in Annapolis, Maryland, located between properties known as 711 Bestgate Road and 713 Bestgate Road in Annapolis, Maryland as surplus property. Resolution number 3720, resolution approving the application of Eleanor R. King to sell an agricultural land preservation easement to the Maryland Agricultural Land Preservation Foundation on 67.5 acres in Davidsonville, Maryland. Resolution number 3820, resolution urging the county executive to lift certain indoor restrictions imposed on restaurants and bars in Anne Arundel County. Resolution number 3920, resolution requesting the Anne Arundel County Department of Health to formulate guidance to safely reopen elementary schools and special education for in-person learning in accordance with guidance set forth by the State Board of Education.
Thank you.
Madam Chair.
Ms. Fiedler.
Thank you. I would like to make a motion to suspend the rules and vote on resolutions 3820 and 3920 this evening.
Ms. Hare.
Second.
Madam Secretary, please call the roll on the motion to suspend the rules to vote on resolutions number 38-20 and 3920 later this evening.
Ms. Fiedler?
Aye.
Ms. Rodvian?
Aye.
Ms. Hare?
Aye.
Ms. Lacey?
Aye.
Mr. Volkey?
Aye.
Mr. Pruski?
Aye.
Ms. Pickard?
Aye.
7 in the affirmative, none in the negative. The motion to suspend the rules to vote on resolution numbers 3820 and 3920 at the end of the evening is passed.
Thank you. Madam Secretary, please read the title of Bill number 55-20 as amended.
Bill number 5520, an ordinance concerning pensions, deferred retirement option program, term of participation period, limitations on interest.
This is an administration bill. Mr. Barron, I will let you introduce your virtual table.
My video will not be turned on. I believe council staff has to, there we go. Good evening, Madam Chair, members of the council. It's good to see you. Bill 5520, oh, sorry, apologies. For the record, Pete Barron with the administration. Joining me at the virtual table will be Ms. Dickerson and Ms. Badowski from Personnel, Mr. Taru from Budget, Chief Wolford from Fire, and Ms. Lori Blair Klausmeyer from Office of Law. And if I didn't say it, Pete Barron with the administration. The purpose of Bill 5520 is to amend the pension code for certain county employees. This bill was discussed at the previous council meeting and the council adopted an amendment. If you'll recall, battalion chiefs require the appointing authority approval for year 6 of the drop. This is the deferred retirement option program, and become eligible to earn interest in year 6 of the drop. Police sergeants and lieutenants no longer require appointing authority approval to extend drop participation for year 6. With that, we ask you pass this bill tonight. And members of the administration are happy to answer any questions.
Ms. Hare, you have the floor.
Thank you, Madam Chair. Jessica Hare, District 7. I think we covered this at the work session, but we had one person who had emailed earlier today or testified regarding the interest rate. And I just want to quickly remember this interest rate is consistent with sort of across the board. This is the interest rate that's used. Is that correct? It's not out of whack.
Pete Barron with the administration. That is my understanding. Ms. Badowski is also shaking her head, and Ms. Dickerson can probably confirm, but that is correct.
Awesome. That's all I needed to know. Thank you so much.
Are there any other questions for the administration regarding Bill 55-20? Seeing none, we will now open the public hearing on Bill number 55-20 as amended. Madam Secretary, do we have any testimony received from members of the public?
No, Madam Chair, we've had no submissions of written testimony on Bill 5520.
The public hearing for Bill number 55-20 as amended is now closed. Madam Secretary, please read the title of Bill 55-20 as amended.
Bill 5520, an ordinance concerning pensions, deferred retirement option program, term of participation period, limitations on interest.
Thank you. Any further discussion from the administration or my colleagues? Seeing none, Madam Secretary, please call the roll on Bill number 55-20 as amended.
Ms. Fiedler?
Aye.
Ms. Rodvian?
Aye.
Ms. Hare?
Aye.
Ms. Lacey?
Aye.
Mr. Volkey?
Aye.
Mr. Pruski?
Aye.
Ms. Pickard?
Aye.
7 in the affirmative, none in the negative. Bill number 5520 as amended is passed.
Madam Secretary, please read the title of Bill number 56-20 as amended.
Bill number 5620, an ordinance concerning purchasing, acquisition of real property by gift.
Thank you. This is an administration bill. Mr. Barron, you have the floor.
Thank you again, Madam Chair. Pete Barron with the administration. Joining me at the virtual table from Central Services, Ms. Harris, and from Law, Ms. Niederer. As with Bill 55-20, Bill 56-20 was discussed at the previous council meeting. The council adopted two amendments, a clarifying and a technical amendment. If you will recall, a constituent would like to donate 0.83 acres of property to the county. This property is undeveloped and forested within the critical area near Herring Bay. A phase one environmental site assessment was completed in February 2020, which identified no recognized hazards on the parcel, and future maintenance costs for the property should be minimal. The budget officer has reviewed and determined no fiscal impact. The council has been provided a map of the surrounding areas, surrounding area as part of the legislative package. If the council approves, Real Estate Division will proceed with receiving this property as a gift according to requirements. We ask that you pass this bill tonight, and we are happy to answer any questions. Thank you.
Are there any questions, Mr. Volkey?
Thank you, Madam Chair. Nathan Volkey, District 3. Mr. Barron or any members of your virtual table can certainly chime in on this, but I wanted to understand, with this parcel, what are the property taxes that are currently being paid by the owner to the county?
I'm going to defer to Ms. Harris, but I recall reading something like $200. Is that correct?
Hi, Samantha Harris, Real Estate Division, Central Services. I do not know that number off the top of my head, but I can find out and get it to you.
This is Christine here with the Office of Law. And I believe in the auditor's report, she noted that the Anne Arundel County property tax bill for the property was approximately $200.
I knew I saw it somewhere. Peter.
Right. Okay, and Nathan Volkey, District 3. So following up on that, obviously that's money that the county is no longer going to get, which it's not a huge amount of money, so I understand why the budget officer said it's a de minimis impact. My next question would be as to the forestation that you're expecting to do on this property. So in the legislative summary, it notes that there is an expectation 18,000 square feet of critical area forest mitigation will happen on this property. But given the pictures that we've seen of kind of what the property looks like and the foresting already on the property, do you expect that you will be able to actually forest 18,000 square feet? I'd asked this weeks ago, and so I'm just following up on that question because I don't know that there was an answer then.
Thank you, Councilman Volkey, Pete Barron, for the administration. It's a good question, and in the original draft of the bill, and there was an amendment where we removed the 18,000 square feet because that will be determined at the time of the mitigation what the exact amount will be. So it may not be 18,000 square feet, it might be. It depends, and that analysis will be done at the time of the use of the mitigation.
Madam Chair.
Mr. Volkey.
Thank you, Madam Chair. Nathan Volkey, District 3 again. So to follow up, assuming that there was 18,000 square feet of property that was able to be forested in the critical area here, and you were able to use this parcel for that purpose, my question would be, what is, I understand the benefit generally of we want to have places to reforest, but is this the place to do it? I guess would be the question. Is this the best place to do it? Have we considered that? How many trees are we getting out of this? How much does this help us for future projects? I just want to understand exactly what the public benefit here is for us accepting this piece of property.
Thank you, Councilman Volkey, Pete Barron with the administration. It's a great question. I take a look at it in sort of two ways. First is the cost that it is for the county to acquire this parcel, which, as you noted, is $200 in foregone property taxes, and the property is donated to the county. The Director of Environmental Policy for the County Executive is in support of the donation for tree plantings, and the property will be held by the Department of Recreation and Parks. So I have to assume that Mr. Johnston, when he reviewed this parcel and the ability, saw more than $200 worth of value to the county.
Thank you. Nathan Volkey, District 3. Thank you, Mr. Barron, for that. I hope to assume that too, but I would have liked to have known it for sure. But I do appreciate the way you answered it because I think that's the crux of the question I was asking. So thank you.
Pete Barron with the administration. If the council would like to reject free land, you are free to do so. Thank you.
Are there any other questions or comments from my colleagues regarding Bill 56-20? Seeing none, we'll now open the public hearing. Madam Secretary, do we have any testimony received from members of the public on Bill 56-20 as amended?
No, Madam Chair, we've had no submissions of written testimony on Bill 56-20.
We did not have any members of the public sign up to speak. The public hearing on Bill number 56-20 as amended is now closed. Madam Secretary, please read the title of Bill number 56-20 as amended.
Bill number 56-20, an ordinance concerning purchasing, acquisition of real property by gift.
Last chance for any comments or questions from the council. Ms. Rodvian.
Thank you, Madam Chair. I guess I would just like to say thank you to the donor for offering up this parcel. I feel like with the regular concerns that we hear about overdevelopment, to have someone offer the county an undeveloped piece of land where there are some trees and space for additional trees, and opening up a little bit of wildlife habitat in an area where there may be other nearby habitat. I think that's wonderful. So thank you.
Well said. Madam Secretary, please call the roll on Bill number 56-20 as amended.
Ms. Fiedler?
Aye.
Ms. Rodvian?
Aye.
Ms. Hare?
Aye.
Ms. Lacy?
Aye.
Mr. Volkey?
Aye.
Mr. Pruski?
Aye.
Ms. Pickard?
Aye.
7 in the affirmative, none in the negative. Bill number 56-20 is passed.
Madam Secretary, please read the title of Bill number 57-20.
Bill number 57-20, an ordinance concerning licensing and zoning manufactured mobile homes located outside a mobile home park. A reminder that the public hearing was continued. This bill is currently up for vote.
Thank you. Mr. Pruski, this is your bill. You have the floor, sir.
Thank you, Councilman Andrew Pruski. We've had numerous discussions at the work session, also in public. I just want to reiterate this bill is actually a constituent that reached out that had an issue with building a manufactured home in my district. We do have an amendment that's going to limit the impact. We did have some concerns in South County and some other areas, and I worked with Councilwoman Hare and others to try and fix that. So that amendment hopefully will pass, and we'll pass this bill at the next meeting. But again, I just want to reiterate, this is very limited in terms of the scope it's going to have and trying to solve a constituent issue. Thank you.
Would the administration like to weigh in at this time?
Thank you, Madam Chair. Pete Barron with the administration. We will reserve comment until after the amendment.
Thank you. Are there any questions from the council? Seeing none, Madam Secretary, please read the title of Bill number 57-20.
Madam Chair, I believe we have an amendment.
Well, but my script says to say what I just said. Please read amendment number 1.
Amendment number 1. This amendment requires that a mobile home outside of a mobile home park be on a contiguous lot of at least 60 acres. And Madam Chair, I suggest we give it a minute because the amendment is now up on screen.
Thank you.
Okay, and you can start discussion.
Is there a motion to
Oh.
adopt?
Yes.
Madam Chair, Councilman Pruski, so move for the amendment.
Is there a second?
Chair, second.
Is there any discussion? Mr. Pruski?
Again, this is very simple. This is addressing an issue, limiting the impact of this. I think for those of you that had questions or concerns, this addresses those. And I'm asking for support of the amendment. Thank you.
Is there any discussion? Ms. Hare?
Thank you, Madam Chair. I had said thank you to Councilman Pruski at the last meeting for holding this so we could work on an amendment. I appreciate your working on this amendment. If everyone remembers, there were a number of concerns about the potential impact and the sheer number of parcels that this might affect with the initial bill. By raising the threshold to that 60-acre level, Mr. Pruski's constituent is still able to be helped, but it doesn't have quite the broad sweeping sort of unintended consequences that the initial bill had. So I just thank you to Mr. Pruski. I am happy to support this amendment.
This is Allison Pickard, Chair, District 2. I had a question for, I guess, Ms. Rhodes. A constituent or two brought to our attention that there are about 1,100 parcels in RA. And the concern was there would be 1,100 mobile homes in South County, essentially. It's my understanding that each of those parcels could have a dwelling of some kind, correct? Just not a mobile home. They could have a brick and mortar house.
Lori Rhodes, Deputy Chief Administrative Officer of Land Use. Yes, if they meet all the zoning requirements and all the requirements for building permits to obtain a certificate of occupancy, yes, it could be occupied by a brick and mortar dwelling.
Okay, so the opposition, it seems to me, is really about a mobile home, not any kind of home.
It's a form of, yes, Lori Rhodes, it's a form of housing, correct.
Correct, okay, thank you. Is there any other comment or questions regarding the amendment? Seeing none, Madam Secretary, please call the roll on amendment number 1.
Ms. Fiedler?
Aye.
Ms. Rodvian?
Aye.
Ms. Hare?
Aye.
Ms. Lacy?
I'm going to briefly explain my vote. I'm not very comfortable with the limitation of 60 acres. I think it's far higher than really should be practicable, and that many more people likely would take advantage of being able to put a manufactured home on RA, and that would be part of what helps solve our housing shortage in this county. At the same time, of course, I recognize the need for a compromise in legislation, and for that purpose, I vote yes.
Mr. Volkey?
Aye.
Mr. Pruski?
Aye.
Ms. Pickard?
Aye.
7 in the affirmative, none in the negative. Amendment number 1 is adopted.
Bill number 57-20 as amended will be heard on October 5th, 2020. Madam Secretary, please read the title of bill number 61-20.
Bill number 6120, an ordinance concerning public works utilities for the purpose of, public works utilities. And a reminder that this bill also, the hearing was concluded. This is up for vote.
Thank you. This is an administration bill. Mr. Barron, you have the floor.
Thank you, Madam Chair. Joining me at the virtual table is Ms. Henry and Mr. Thompson from Department of Public Works, Ms. McQuaid from Finance, and Ms. Kenny from the Office of Law. As Council Administrator noted, this bill was discussed at the previous council meeting. It was also discussed at the council work session. As a recap, the purpose of Bill 6120 is to make corrections and changes to various provisions of Article 13 pertaining to utilities and water and wastewater procedures. The bill provides clarifying language for backflow prevention, which is vital and necessary to protect the county's drinking water supply. Improperly functioning or lack of a backflow preventer can cause tainted liquids to backflow into the water supply and cause contamination of the county's drinking water. There are some other changes in the bill. Revision to change the time frame for replacement of a water meter on a private water source from every 10 years to every 15 years. It deletes language that authorizes back billing for water or wastewater usage only when there is an omission or mistake of the customer, and would allow back billing for a period not to exceed 3 years for any billing that is incorrect or not made. It revises provisions allowing for waivers of water and wastewater usage bills for uninhabitable and certain unoccupied properties, increases the amount that DPW may reimburse to a residential customer for property damage as a result of sewer system backup into the customer's home, require that whenever water service is turned off for a lack of a backflow preventer, a service charge be applied, and a meter test is added to the list of items that are subject to a charge as well. It is our understanding there will be a couple of amendments offered. Many of them were discussed at the work session. The administration is happy to answer any questions on either the bill or when we get to the appropriate time on the amendments.
Are there any questions or comments from my colleagues before we move to amendment number 1? Seeing none, Madam Secretary, please read amendment number 1. We'll wait for it to be pulled up.
Amendment number 1. This technical amendment corrects the short title to more clearly state what the bill is about.
Is there a motion to adopt?
So moved, Volkey, District 3.
Is there a second?
Second, Amanda Fiedler, District 5.
Is there any discussion on this amendment? It seems quite clear. Mr. Volkey?
Oh, I was just going to say it's a technical amendment. Thank you.
Madam Secretary, please call the roll on amendment number 1.
Ms. Fiedler?
Aye.
Ms. Rodvian?
Aye.
Ms. Hare?
Aye.
Ms. Lacy?
Aye.
Mr. Volkey?
Aye.
Mr. Pruski?
Aye.
Ms. Pickard?
Aye.
7 in the affirmative, none in the negative. Amendment number 1 is adopted.
Madam Secretary, please read amendment number 2.
Amendment number 2. This amendment removes that the back billing can happen for a non-customer omission or error and retains code language as it is currently written.
Is there a motion to adopt?
So moved, Volkey, District 3.
Is there a second?
Hare, second, District 7.
Is there discussion on amendment number 2? Ms. Rodvian?
I can let the makers of the motion speak first.
Mr. Volkey?
Thank you, Madam Chair. Just quickly, we talked about this at the work session. This takes out the idea of back billing, as it says, for a non-customer omission. So that was the idea. We talked about this pretty extensively at the last meeting and again at the work session. If there are any questions, I'm happy to discuss.
Ms. Rodvian?
Ms. Rodvian, you're muted.
Thank you. Ms. Hare, did Councilwoman Hare want to chime in about, something as a co-sponsor of this motion before I ask my questions?
Sure.
Ms. Hare?
Thank you, Madam Chair. Thank you, Councilwoman Rodvian. Jessica Hare, District 7. I just wanted to say I struggle with the idea of presenting a homeowner, suddenly sort of without expectation, $1,000 because you haven't realized that you've been incorrectly billed for the last 2 years, 3 years, whatever it is. And I think it's just a hard concept for me to take hold of, that we could do that to a homeowner unsuspectingly.
Ms. Radvian.
Thank you, Madam Chair. Councilwoman Radvian, District 6. I apologize if this was addressed at the work session that I could not attend last week, but do we have an estimated cost to the county of, I guess, basically waiving those sort of non-homeowner errors from payment?
This is Pete Barron with the administration. Thank you. It's a great question, Councilwoman Radvian. Just real quick, I'll sort of back up a little bit and go through the administration's position on this amendment, and then answer that question and turn it over to Ms. Henry, if that's okay, for a little more detail, or maybe Ms. McQuaid has a little bit more they can add on this. So the administration wants to make it clear that we also, like Councilwoman Hare, struggle with the notion of a surprise bill that a customer may receive, and very sympathetic to individuals who might not have expected to see a bill. But I think there's a few things the council should keep in mind if it decides to accept this amendment. First is that the customer that received the back bill did use the water that was provided. So I believe in the hearing, there was an analogy made to Monopoly and a community chest card, bank error in your favor, and you get $10, and I think you get to go or something. It's been a while since I played Monopoly. In the real world, if the bank makes an error in your favor, they get the money back or they charge you criminally. Just to be clear, the customer may not expect a bill, but they did use the water. To answer your question directly, Ms. Radvian, we estimate that it's approximately $50,000 per year that it would be spread across the system. Water is an enterprise fund, so it needs to be self-sustaining, which means that this the folks who receive the benefit of the underbill that underbill would have to be distributed across the entire system. So as I said at the work session, the administration does not have an objection if this council wants to remove this provision of the bill. We do understand and are sympathetic to the shoes of somebody who might not have expected to receive this bill. In further review of this issue, when we were looking at it and discussing it after the work session, it was pointed out that BGE and other utilities do provide back billing provisions. The Public Service Commission allows for a 3-year back bill as well. So this is a decision that this council needs to make from a policy matter. Is this money will have to come from somewhere, and so whether one ratepayer is paying for the water that they used and were incorrectly billed for, or the mistake is distributed across the system, that's a policy decision for this council. And I think I talked a little bit longer than I expected to. So Ms. Henry and Ms. McQuaid, I apologize, but correct me if I'm wrong. To Ms. Radvian's question, it's a little difficult to estimate, but we do estimate it's about $50,000 spread across the system per year.
Hello, this is Karen Henry. I'm the Assistant Director of Public Works. Yes, $50,000.
is what our estimate is. And I don't have anything further to add other than if it is a hardship for the customer, one, we have a payment plan. And if there's a hardship that's they just cannot afford to pay, we would connect them with services that may be able to assist them with bill paying.
Ms. Lacy.
Thank you, Madam Chair. Sarah Lacey, District 1. I have a couple of related questions. First is, does the Maryland Public Service Commission regulate any of the subject matter in this bill?
Hi, this is Karen Henry.
Good.
Kelly looks like she's going to answer it as well. Karen Henry again, Public Works, no, they do not.
Okay, well, that's good to know. Then we don't have to know what they think about this subject, because I think they do have an opinion when it comes to electricity and other utilities. That would be the same question. And I'm pretty sure their opinion is you can back bill the customer. I think it's a little bit like the principle of, whether or not you're going to have one person or the whole pay for the mistake. And it seems to me that if we can't collect this money, isn't there sort of a perverse incentive to not catch the problem?
Pete Barron with the administration. That's why this council gets paid the big bucks. It's a policy decision that you have to make.
If I may add, this is Karen Henry again, Public Works. The reason we put this in there, as I mentioned in the other hearings, is we've had experiences where there have been, and in the cases that come to mind immediately, they were commercial entities that the error was in their favor. And it was $9,000 and $10,000. The two made, that is the reason we put this in there, is that we'd have some way of, and I think we have in there may back bill. It's not we will absolutely back bill, but that we have some recourse for those high users that were able to get quite a bit of water and were missed in our appropriate charging.
This is Allison Pickard, Chair, District 2. I have a comment and maybe there's a question in here. So obviously this bill is potentially coming back amended. While the residential customer, it could be quite difficult to receive a $1,000 water bill that wasn't their mistake. Is there a way to differentiate between those commercial entities that have gained free water at the expense of the taxpayer, or is it sort of, from a legal perspective, is it one size fits all here with the solution?
Pete Barron with the administration. Madam Chair, that's a great question, and I'll defer to the Office of Law on the legality of splitting commercial and residential. We discussed that internally, and it's kind of a difficult line to draw. If you are, say, a landlord, you're technically and you hold the property in an LLC, you're technically a commercial entity. So how do we define that? Is it by the underlying zoning? And it became more of a matter of the policy decision that's before this council, and what this amendment speaks to is whether or not the customer, regardless of whether they're a residential customer or a commercial customer, are if they get the benefit and the cost is spread across the whole system, or the entity, whether it be an individual or the commercial entity, has the burden of paying for the mistake.
Thank you for that. Ms. Hare.
Thank you, Madam Chair. Jessica Hare, District 7. When we talk about the burden being spread across sort of the whole system, we talk about it in terms of setting rates for future years. Is that correct?
Ms. Henry is nodding yes. Pete Barron with the administration. I trust Ms. Henry's read on this.
Okay, perfect. Thank you.
Are there any questions or comments on amendment number 2? Seeing none. Madam Secretary, please call the roll on amendment number 2.
Ms. Fiedler,
Aye.
Mr. Rodvian,
I'd just like to take a moment to explain my vote. I really do appreciate the spirit of this amendment. I'm going to vote nay because I do believe that DPW, it sounds like they have some discretion here to help the homeowner or the ratepayer address the issue. So I think that there is a little bit of cushion if it is needed in cases where it's needed, but in the interest of fairness, it really should be paid for by the person who used the service. So I will vote nay.
Ms. Hare,
Aye.
Ms. Lacy,
Nay.
Mr. Volkey,
Aye.
Mr. Pruski,
Nay.
Ms. Pickard.
Aye.
4 in the affirmative, 3 in the negative. Amendment number 2 is adopted.
Madam Secretary, can we pull up, please read amendment number 3?
Amendment number 3. This amendment removes a proposed new service fee allowed for restoration of water under certain circumstances.
Is there a motion to adopt?
So moved, Madam Chair. Nathan Volkey, District 3.
Is there a second?
Second, Amanda Fiedler, District 5.
Mr. Volkey or Ms. Fiedler, who would like to discuss this amendment?
I can take it, Madam Chair. Nathan Volkey, District 3. Thank you. So the purpose with this amendment is to remove the proposed new service fee that would be included when there is a restoration of water, simply what the summary states. The reason for this is currently it sounds like from what we could ascertain at the work session that DPW is in large measure already doing this work. But what it sounds like is that we have a situation where we're trying to find a way to bill for that now. And so that is what's being added on here. With that, I'm not seeing the need for the new fee and how much of a new imposition of a burden or cost this is on county on county government officials that should therefore be borne by the taxpayers. So that's my rationale for why I put this forward. And if Councilwoman Fiedler has anything to add, please do.
Ms. Fiedler?
I'd just like to echo the sentiments of my colleague. He did a wonderful job explaining why I'm co-sponsor of this amendment.
Would the administration like to weigh in on amendment number 3?
Thank you, Madam Chair. Pete Barron with the administration. We respectfully ask the council to reject this amendment. Amendment 3 aligns restoration of water service fees with that already included when service is turned off due to unpaid usage fees. The department does and must redirect resources away from planned and programmed work to restore service. So there is an indirect cost and lost productivity. As mentioned on the previous amendment, it is an enterprise fund and a closed system. So there is cost incurred for activities like this. And we feel this fee is reasonable and fair.
Is there any further discussion or questions for the sponsors or the administration on amendment number 3? Seeing none, Madam Secretary, please call the roll on amendment number 3. You're muted.
Thank you. Ms. Fiedler,
Aye.
Ms. Rodvian,
Nay.
Ms. Hare,
Aye.
Ms. Lacy,
Nay.
Mr. Volkey,
Aye.
Mr. Pruski,
Nay.
Ms. Pickard.
Nay.
3 in the affirmative, 4 in the negative. Amendment number 3 is defeated.
Madam Secretary, please read amendment number 4.
Madam Chair, if I may, Nathan Volkey, District 3. I plan to withdraw this amendment, so there's no need to present it.
Amendment number 4 is hereby withdrawn.
Thank you.
Madam Chair,
Ms. Fiedler.
I would like to introduce amendment number 5. Our Assistant Administrative Officer, Ms. Corby, will be sharing it momentarily. In the spirit of not surprising members or residents of Anne Arundel County with back billing up to 3 years ago, I've drafted a compromise amendment that would say up to 50%.
Madam Secretary.
I have an amendment number 5.
Yeah.
Chair.
Yes. So
yes.
I'm sorry, there was some last minute changes to amendments. I can certainly bring up what is now, I can bring up Ms. Fiedler's amendment that is amendment number 6 at this point in time, and we can change it to 5 if the council would like to do that. Or we can just proceed with 5 and then go back to 6.
Ms. Fiedler.
Madam Chair, I'm fine with that. Thank you.
Madam Secretary, please read amendment number 5.
I want to make sure this is the correct one, so I shall wait for it to come on the screen. Okay, my apologies. I see on the screen amendment number 6. Is that the amendment we are working on? Because my amendment number 5 is different.
Yes, I think we were going to work with the initial amendment.
This one.
There we go. Thank you.
Thank you. Amendment number 5. This amendment requires that prior to turning off water service due to an improperly functioning backflow preventer, the department provide an owner with notice to install, test, repair, or replace a backflow preventer within 90 days of a first notice or 30 days of a second notice.
Is there a motion to adopt?
Chair, District 7, so moved.
Is there a second?
Second, Volkey, District 3.
Thank you. Ms. Hare, would you like to discuss your amendment?
Yes, thank you, Madam Chair. Jessica Hare, District 7. The description on the amendment is quite accurate, and I appreciate the administration working with me on this amendment. We had a bit of discussion at the work session. There's a penalty or a potential penalty in the bill, the way it's drafted, to turn off someone's water for having a backflow preventer that is either not working or can't be tested. And we heard some numbers at the work session about a number of thousands of homes that may have this problem. Kind of in line with the First Amendment, I'm a little bit concerned about the idea that you could just shut off someone's water without first giving them the opportunity to correct the problem and really making sure they have adequate notice. I raised this concern at the work session, talked about it with the administration afterwards, and we've come up with this compromise, which essentially requires that DPW provide 2 notices to the homeowner to fix the problem or the whatever entity may own it. The first gives them 90 days to fix it. The second gives them 30 days to fix it. And at that point, then their water could be turned off if they failed to fix this. It's my understanding that it would be any property built after 2015 needs to have one of these based on the code language. So that's the properties that we'd be working with.
Would the administration like to weigh in on this amendment?
Thank you, Madam Chair, Pete Barron with the administration. Echo what Councilwoman Hare said. This was a point of discussion during the work session. we huddled afterwards and came up with this language. The only maybe addendum or proposed correction to Councilwoman Hare's comments, I wouldn't characterize this as a compromise. This was what DPW was planning on doing anyway. We would not arbitrarily shut off folks' water, but this will codify the practice we were planning. So that in and of itself is perfectly acceptable, and the administration appreciates Councilwoman's raising the issue, and we support.
Ms. Lacy.
Thank you, Madam Chair. A couple of questions. First, is it true that this particular, I guess I should just say what Councilwoman Hare mentioned, that this will apply mostly to homes built after 2015?
Pete Barron with the administration. I'm going to ask Office of Law or somebody from DPW to weigh in. But yes, the devices will, we aren't requiring retrofitting of houses that were built before it existed in the code. If that is correct, please, if that is incorrect, please correct me, somebody.
Okay, well, this is Sarah Lacy, District 1 again. I say that because I don't remember that being mentioned at the work session at all. And if it was, I completely missed it, but I really don't think so. And it puts me in a little bit of a quandary because, in fact, my house was built in 2016. My whole neighborhood was probably built after 2015. And so now I have to think about this bill in a bit of a different light. But I can say that, at least with respect to what I see in the amendment before us, one thing it seems to lack is putting any obligation on the homeowner to notify DPW if they have made the repair that DPW is asking them to do. And if the customer does not need to notify DPW, then that seems to impose additional costs on DPW that I don't think the whole system should bear.
Mr. Thompson is an expert on how this actually functions, so I'm going to ask him to weigh in on that point because it's a really good question.
Thank you, Ben Thompson, Department of Public Works Utility Administrator for Water Operations. The date in question of 2015 really correlates to the change in the plumbing code, especially as it relates to the fire suppression systems. Prior to 2015's fire suppression systems were installed with a non-testable device. They were replaced per manufacturer's recommendations, failures, things of that nature. But with the change in plumbing code in 2015, all new construction going forward are now built with a testable device that requires a homeowner to have them tested annually to make sure they're properly functioning. And if they do fail, so a plumber, we send out notices to the homeowner so they're aware that the test date is coming up. And then once they have it tested themselves and or the plumber, the certified plumber that does the testing, sends us the results whether it passes or fails. And then we have the additional follow-up with them to make sure it's corrected.
Ms. Hare.
Thank you, Madam Chair. I'm just Jessica Hare, District 7. I was just going to say my apologies to DPW. I did not mean to imply that you would be cruel or mean in shutting off people's water. I just meant as a compromise in terms of what's stated in the bill presently. That's all.
Is there any further discussion on amendment number 5? Seeing none. Madam Secretary, please call the roll on amendment number 5.
Ms. Fiedler?
Aye.
Ms. Rodvian?
Aye.
Ms. Hare?
Aye.
Ms. Lacy?
I abstain.
Mr. Volkey?
Aye.
Mr. Pruski?
Aye.
Ms. Pickard?
Aye.
6 in the affirmative, 1 abstention. Amendment number 5 is adopted.
Ms. Fiedler.
Thank you, Madam Chair. Amanda Fiedler, District 5. I would like to leave the roll taking up to our administrative officer and withdraw amendment number 6.
Amendment number 6 is withdrawn.
Bill number 61-20 as amended will be heard on October 5th, 2020. Madam Secretary, please read the title of Bill number 62-20.
Bill number 6220, an ordinance concerning public safety off-the-road motorcycles.
This is Mr. Pruski's bill. Mr. Pruski, you have the floor.
Thank you, Madam Chair. Councilman Pruski, District 4. We had a lengthy discussion, and well, I shouldn't say lengthy, but we had a discussion at the work session regards to this bill. I've had several constituents reach out to me that have had loud motorbikes riding in a neighborhood, and we tried to work with the police department and other folks. Again, these are off-road vehicles that are not registered. I'll repeat that again, off-road, and it's 300 feet within a dwelling. To understand what 300 feet is, take a football field, remove both end zones, and that's how far it is. It's like an air conditioner running. So I just didn't want to let you know that. Also, I realized that we have some rural areas in our county where someone may allow this activity to occur, and we certainly don't want that to be an issue. So we do have an amendment that we'll be submitting here forward, where if you have property owners or adults that live next door, these facilities, if they get permission, that wouldn't be an issue. But again, I'll leave it at that. It's a pretty simple law trying to address a noise nuisance from that end, and I'll leave it there. Thank you, Madam Chair.
Mr. Barron, would the administration like to respond to this bill?
Yes, thank you, Madam Chair. Pete Barron. The administration supports this bill. We do understand there is an amendment coming. It seems like it's a pretty very reasonable intent of the sponsor to make sure that some very loud toys do not disturb the quiet enjoyment of a neighborhood.
Are there any questions from the council on Bill 62-20? Seeing none at this time, we will now open the public hearing on Bill number 62-20. Madam Secretary, do we have any testimony received from the members of the public?
Yes, Madam Chair, we had one submission of written testimony, which was shared with the council and posted on the council website.
Thank you. We will now hear from members of the public who signed up ahead of time. We have one person signed up to speak on this bill. Remarks will be limited to 2 minutes. When it is your turn, please unmute yourself and begin stating your name and address for the record. We will begin with Mr. Edward Evans. Thank you, Mr. Evans. Are you with us?
Yes, I'm here. Can you hear me?
We can, sir. Yes, you have 2 minutes. Please state your name and address for the record.
Yes, my name is Edward Evans. My address is 769 Old Harold Harbor Road in Crownsville, Maryland. First, I'd like to thank the council for the opportunity to testify. I hope all of you are well and stay safe in this situation here we have. I am an Anne Arundel County resident living in the Harold Harbor, Arden area. And we have had a long history of dirt bike issues within this area. And where the properties here include some acreage, most of the properties are divided up into long rectangles rather than perfect squares. For instance, where I have 3 acres, it is only approximately 170 feet wide, and our house sits in the middle. Our neighbor on one side is in the habit of allowing 3 to 4 pickup truck loads full of friends with dirt bikes to unload and ride round and round within 50 to 75 feet of our house. Although they are within a few feet of the neighboring property, within their property, the constant roar of anywhere from 6 to 14 of these dirt bikes is absolutely deafening and constant from sun up to sundown. We cannot even hear our own conversations within the house, let alone outside. We cannot hear our TV or talk on the phone. Along with the noise is also the dust that gets kicked up in the air and floats around. So not only would this mess up a freshly power washed house and its windows, it prevents us from having a barbecue or cookout or enjoying our patios and picnic areas outside.
Thank you, Mr. Evans. Your 2 minutes is up.
Okay, thank you.
It's hard to hear that buzzer, but it did go off. So thank you for joining us tonight. Well done.
Thank you.
The public hearing on bill number 62-20 is now closed. Madam Secretary, please read the title of bill number 62-20.
Bill number 6220, an ordinance concerning public safety off-the-road motorcycles.
Is there any further discussion? Seeing none, I believe there's an amendment. Madam Secretary, please read amendment number 1.
Amendment number 1. This amendment requires that the person providing consent to operate an off-the-road motorcycle within 300 feet of a dwelling is an adult resident of the dwelling.
Thank you. Is there a motion to adopt?
So moved, Madam Chair, Councilman Andrew Pruski.
Is there a second?
Councilman Radvan, second.
Mr. Pruski, would you like to discuss your amendment?
Yes, thank you, Madam Chair. So when we were doing this bill, as many of you know, we try and be reasonable. And certainly you heard the testimony by Mr. Evans that someone is being unreasonable. But we also know that we have a lot of rural and agricultural area in our county, and some folks may not have an issue with motorbikes within 300 feet. We did go back and forth with the law office, and also thank you to Ms. Stewart, our council attorney, and Mr. Volke, thank you as well. We looked at possibly having the property owner, rentee, but honestly, the way the code is written in the law, as I said, I'm not an attorney, but I play one on TV, that the adult permission next door, and of course, the police could ascertain that. I know we got into the ifs, ands, and buts, but ultimately, this covers if somebody doesn't have an issue. And so, again, in Mr. Evans' situation, where you have lots that are very narrow and you have neighbors that are really upset, I think it addresses it. Again, if you're in other areas where this may be a concern and folks have a permission, the police go out, they can make a judgment call. They do that in many other things. So that's why I'm asking for this amendment. I think it makes common sense and also limits kind of the area, and I'll leave it at that. Thank you.
Is there any, would the administration like to respond on amendment number 1?
Thank you, Madam Chair, Pete Barron with the administration. First, I want to correct an error in my initial testimony. Or an oversight, I neglected to introduce Major Passman from police and Ms. Kenny from the Office of Law. If you have any questions on the bill, the administration supports this amendment. It makes sense. There are plenty of people like myself who think these things are cool, so we might not have a problem.
Are there any questions regarding or concerns from my colleagues regarding amendment number 1? Seeing none, Madam Secretary, please call the roll on amendment number 1.
Ms. Fiedler?
Aye.
Ms. Rodvian?
Aye.
Ms. Hare?
Aye.
Ms. Lacey?
Aye.
Mr. Volke?
Aye.
Mr. Pruski?
Aye.
Ms. Pickard?
Aye.
7 in the affirmative, none in the negative. Amendment number 1 is adopted.
Thank you. Bill number 62-20 as amended will be heard on October 5th, 2020. Madam Secretary, please.
Pardon me, Madam Chair, my apologies. As you know, we are at the 90-minute mark, and it will be necessary to go into at least a 10-minute recess.
Yes.
For the transcriber.
Yes. May I have a motion to recess for 10 minutes?
Lacey, so moved.
May I have a second?
Pruski, second. Councilman Pruski, second.
All in favor? Aye.
Aye.
Opposed? The motion carries. We will return at 7:40 Thank you. Madam Secretary, I see we are all coming back in here. It is now 7:40. And we're here. Madam Secretary, please call the roll.
Ms. Fiedler,
Present.
Ms. Rodvian,
Present.
Ms. Hare,
Present.
Ms. Lacy,
Present.
and Mr. Volkey,
Present.
Mr. Pruski,
Here.
Ms. Pickard.
Here.
Madam Chair, all council are present.
Thank you. Madam Secretary, please read the title of Bill number 63-20.
Bill number 6320, an ordinance concerning public safety, electronic smoking devices in restaurants, prohibition.
Mr. Pruski, this is your bill. You have the floor, sir.
Thank you, Madam Chair. Andrew Pruski, Councilman District 4. Unbeknownst to me, I had a constituent go to an Anne Arundel County restaurant, walked in, ordered food. All of a sudden, there was a person next to them who was using a electronic smoking device. And essentially, they went to the manager, and the manager said, "I'm not aware of any rule that doesn't prevent this from being a prohibition in Anne Arundel County." And so we did some legal research, and electronic smoking devices are not covered under the current code and ordinance. So that includes pipe, tobacco, cigars, other things in restaurants. Again, I want to reiterate that this is concerning in restaurants for the purpose of prohibiting. This does not, along with the code, prohibit someone from going in a smoking area by a restaurant, going outside. This is inside a restaurant. We will have an amendment. There was some clarity that needed to be had, and we'll talk at the appropriate time about who enforces such item. But besides that, this is pretty straight and clear forward. It's a policy decision by the council. And I do believe, again, electronic smoking devices are something that are new. They haven't been around for a while, wasn't really covered in the code, and I'm hoping to address that. And I'll leave it there. Thank you, Madam Chair.
Would the administration like to weigh in on Bill number 63-20 at this time?
Thank you, Madam Chair. Pete Barron with the administration. Joining me from Health is Mr. Kurdian, from Police, Major Passman, and from Law, Miss Kelly Kenny. Want to say the administration strongly supports this bill. Want to thank the sponsor for working with us on a couple of our, I'll call them logistical concerns with where the enforcement lives, and we'll be discussing that in the amendments to come. I guess one thing I did say on the sponsor's previous bill is it was dealing with something that is cool. Vaping is not cool. So with that, administration asks you to support the bill.
Are there any questions for the sponsor or the administration from the council on Bill 63-20? Seeing none, we will now open the public hearing on Bill 63-20. Madam Secretary, do we have any testimony received from members of the public?
No, Madam Chair, we've received no submissions of written testimony.
Thank you. We did not have any members of the public sign up to speak. The public hearing on Bill number 63-20 is now closed. Madam Secretary, please read the title of Bill number 63-20.
Bill number 6320, an ordinance concerning public safety, electronic smoking devices in restaurants, prohibition.
Thank you. And as there was no conversation previously, we'll just move to amendment number 1. Madam Secretary, please read amendment number 1.
Amendment number 1. This amendment rewrites the bill to prohibit the indoor use of electronic smoking devices in restaurants located in the county and grants responsibility for administering and enforcing this law to the Health Department.
Is there a motion to adopt?
Councilman Pruski, motion to adopt.
Is there a second?
Councilman Rodvian, second.
Mr. Pruski?
Thank you, Madam Chair. Like any bill, again, Councilman Andrew Pruski, District 4. Like any bill, you want to make sure you have it right. There was some debate back and forth. Some people were on vacation, other things, but we straightened it out. And the amendment essentially clarifies that this lies within the health department and similar with other tobacco uses when it comes to restaurants and other things. So this is just a clarifying amendment about who enforces the issue. Simple as that. Thank you again.
Is there any discussion, questions, or comments from my colleagues on amendment number 1? Would the administration like to weigh in on this?
Sure. Thank you, Madam Chair. Pete Barron with the administration. Just want to thank the sponsor, council, attorney for working through this. We appreciate the sponsor putting this amendment in. Health is the proper place for this to live. Thank you, and please move the amendment.
Thank you. I see no further flags, so Madam Secretary, please call the roll on amendment number 1.
Ms. Fiedler?
Aye.
Ms. Rodvian?
Aye.
Ms. Hare?
Aye.
Ms. Lacy?
Aye.
Mr. Volkey?
Aye.
Mr. Pruski?
Aye.
Ms. Pickard?
Aye.
7 in the affirmative, none in the negative. Amendment number 1 is adopted.
Thank you. Bill number 63-20 as amended will be heard on October 5th, 2020. Madam Secretary, please read the title of bill number 65-20.
Bill number 6520, an ordinance concerning zoning, mixed-use districts, workforce housing.
This is Ms. Lacy's bill. Ms. Lacy, you have the floor.
Thank you, Madam Chair. Sarah Lacy, Councilwoman for District 1. The bill addresses the ability of a developer to substitute workforce housing for an office use within a mixed or MXD, as it reads in our code, mixed use district. So we have a few different categories of mixed use districts. One thing that the bill does is it takes in the mixed use residential category, it allows substitution such that whatever percentage of office space was originally part of the plan within that district, as much as none could be of office space could be built in that district, and it could all be replaced with workforce housing as a possibility. But the bill is aimed at increasing flexibility for how a developer can use the office space within those mixed use zones. And given that the demand for office has been in decline for quite a long time, including well before the pandemic, we have unused parcels in areas that we have planned previously to be of higher density or more intensive use. That's what these mixed use districts are for. So if you have a significant portion of land sitting around not being developed into the more intensive use that was planned, you can see why both developers would look for an alternate way to use that land, and the county I think would benefit from this kind of substitution. Would further our policy goals of constructing more workforce housing and affordable housing in the county within the framework that currently exists. This bill does not change anything about any notification processes that apply, and it does not create any exemptions from the adequate public facilities ordinances for roads or schools, which already don't exist for workforce housing. So none are created in the bill. The other thing the bill does is it says if you're substituting workforce housing for an office use in any of these mixed use districts, then the nature of what you build needs to be in the nature of workforce housing, not like the whatever other types of buildings there are in that given district. So the bill exempt from what otherwise applies in the district. It primarily applies to height limitations, and it just says the bill essentially just says we're just following what's already in our code, in a separate portion of our code that governs workforce housing. So with that, I'm happy to take any questions, and I ask for your support.
Mr. Barron, would the administration like to weigh in on Bill 65-20?
Thank you, Madam Chair. Pete Barron with the administration. We would be happy to weigh in. From Office of Planning and Zoning, we have Mr. Kai Ziegler and Ms. Rhodes. From ACDS, we have Ms. Koch. And from Law, we have Ms. Blair Klausmeyer joining at the virtual table. The sponsor said it well. I think there's been a lot of discussion over the last couple of days on this bill. So I just want to echo a couple of the points the sponsor made, and apologies because she covered everything, and I think I'll be repeating a little bit. But as the sponsor mentioned, all adequate public facilities ordinances must still be followed. Mixed use zones aren't changed except to allow the swapping of one particular type of mixed use, that's office, which as Councilwoman Lacey pointed out, the market has changed and the demand for office is significantly different even before the pandemic, and I can imagine every business will be taking a hard look at what their needs are as we return to normal. And as Councilwoman Lacey noted, this bill does not allow a public meeting to be avoided if a change is in designation, or if a change in use is made, the public would still have the opportunity to speak up. This administration is firmly committed to protecting the environment by using smart growth strategies. We believe that this bill does just that by locating workforce housing in areas already zoned for high density uses. We are making our county a more affordable place for teachers, firefighters, and police officers to live without furthering the kind of sprawl that threatens our forests and our watersheds. So I just want to reiterate, like any land use bill, this is complicated. So there's a lot of competing information out there, but the facts are pretty clear. This is specifically targeted to one type of zoning classification of mixed use, and provides one option for a additional workforce housing, which we know, and I mentioned this at the work session, we know we need to have a strong and thriving economy, let alone a affordable place for folks who do work in the county in roles such as teachers, firefighters, and police officers. So with that, the administration supports this bill, and we're happy to answer any questions you may have.
Thank you. Do I have questions and comments from my colleagues? Ms. Hare.
Thank you, Madam Chair. Jessica Hare, District 7. I'm wondering, maybe Ms. Rhodes, maybe you could help me understand sort of a practical parcel and what it might look like if you have 100 acres or 10 acres, however you'd like to go with it. Can you give me an example of sort of what percentage or how many units of workforce housing might go on there under this bill versus what square footage of office and residential might have gone under it if this bill were not to exist? I'm just trying to understand this intensity of use and what might be going in versus what could go in now.
Good evening, Lori Rhodes, Deputy Chief Administrative Officer, Land Use. This bill would allow a 100-acre parcel zoned MXDR to combine the category of uses, which would consist of residential, and there's a threshold of 50 to 80%. The office use would be allowed to be substituted by workforce housing that would cover that what was 10% to 0 to 25%. They could either not provide any office and substitute it for workforce housing, but then they would also have to provide a threshold of retail and service uses 5 to 25%. And that would all be combined in this mixed use development, which is supposed to be a compact urban type of development, as opposed to a low density residential development where there's sprawl. So that's the whole intent of mixed use, is to get all those uses mixed together, compact, where they're walkable, near transportation. That's the goal. And the density would be based on the charts that's provided in the code. So for workforce housing, it would be regulated by the conditional use provisions in Title 10.
Madam Chair, may I ask a follow-up?
Sure.
Thank you. Thank you. Jessica Hare, District 7. So Ms. Rhodes, do I understand this chart correctly that theoretically in an MXDR zone, you could have up to 95% be residential workforce housing, and that the bulk regulations for R22 would apply to those parcels?
The bulk regulations for MXDR would apply for the portion that's residential. And then the portion that's workforce housing, it would be governed by Title 10. And that would be that portion that's 0 to 25. So they would have to do the math to determine how much regular MXDR there would be versus the workforce housing, but it can only be the substitution of the office. I don't know if I confused you, but.
No, I think that's helpful. So you could have a maximum of 25% workforce housing, which would be replacing what was the office. Do I understand that correctly? And then the rest be a mix of it. Okay, and that 20.
Right. And you would still have to meet the coverage and all of the requirements for adequacy of public facilities in order to implement this use.
Okay, and that's that R22 and the setbacks and whatnot, that's in the other portion of the code?
For the workforce housing portion only.
Okay, thank you very much.
Are there any other questions? Ms. Rodvian.
Thank you, Madam Chair. Lisa Rodvian, District 6. This is probably a question for Ms. Rhodes. Just to clarify, under the current law, under the MXDR zoning, which is the one that we're really looking at here, you could already have pretty high density development. Is that a fair description?
Lori Rhodes, Deputy Chief Administrative Officer, Land Use. That is correct. You can currently have 50 to 80% residential and 10% office and 5 to 25% retail. It gives the developer the flexibility to have a mix of use, to have this type of smart growth, which is compact, walkable, having a mix of uses in an urban setting. That's the goal of the mixed use development.
Okay, so I think one of the items of confusion that I've heard from constituents frequently with respect to this bill is that it would be allowing high density in a place where high density would not have otherwise been allowed. But this basically would allow a different type of high density and in a place where high density was already allowed. So this is not taking places that were previously zoned for something much lower density like R1, for example, or even R4.
Lori Rhodes, correct. MXDR currently allows 7 dwelling units per acre. The office component would be substituted by the workforce housing, which allows up to 22. MXDR density spans from 7 dwelling units per acre in MXDR to 15 dwelling units per acre in MXDC and E, and to 22 dwelling units per acre in MXDT. Yes, it was intended for more intense, higher density, compact development. That's the whole intent and why this zoning district is in the ordinance.
Okay, thank you very much.
Ms. Hare.
Thank you, Madam Chair. Jessica Hare, District 7. I think this question is also for Ms. Rhodes. You very kindly sent a map earlier today because I had asked about the Route 3 corridor in general. Candidly, I've gotten a lot of responses separately, not related to this bill specifically, but the general development plan and things like that along that Route 3 corridor because it has been so plagued by sort of a lot of development recently. And there are a number of parcels, I believe they're actually in Councilman Pruski's district, but they are right there on that southbound side of Route 3. Do you have an idea of the number of acres that those parcels encompass? It looks like, if I remember correctly, it was 6 or 7 different parcels that were all zoned MXDR.
Lori Rhodes, I do not have the number of acres for the Maryland 3 parcels, but in total, there was, I believe, 182 acres, 32 parcels, but we only have 3 projects that would be impacted by this bill. And they're in Laurel, Hanover, and potentially in Crofton if they decided to come forward with the workforce housing project.
Okay, and okay, all right, I think that's all for now. Thank you.
Ms. Fiedler.
Thank you, Madam Chair. Amanda Fiedler, District 5. Do we have any trip calculation information comparing office space uses versus high density residential?
Lori Rhodes, I do not have that information available at the moment, but I would have to reach out to inspections and permits engineering section to give me those ITE ratings for this use. So that's something I could provide for you.
Amanda Fiedler, District 5. Thank you. That would be very much appreciated. And I do want to thank you for sending over the map today that helped clarify some questions I had with the 5th District.
You're welcome.
This is Allison Pickard, Chair, District 2. I had a question regarding this bill and really some of the constituent concerns that we've received. There was comments regarding the current ongoing GDP conversation and the thought of this bill sort of retooling the mixed use designation. And as I've not gone through the general development planning process, I wanted to understand when during that process that's coming to the council, would the council be looking at the various mixed use designations with the eye of altering the percentages to better suit the market and the viability that's, you know, in today's economy? Is that something that will come through the GDP, or is that through comp rezoning? And anyone can answer that.
Either myself or Steve Kai-Ziegler.
Hey, good evening. This is Steve Kai-Ziegler, Planning and Zoning Officer. Excellent question. I think what you'll find is as the GDP comes forward, this will be a part of the discussion amongst both the council and members of the public. Let's say the GDP is adopted. The administration, Lori, is very aware. We plan to bring forward a variety of larger scale text amendments to major portions of the zoning and subdivision code. I think that is the proper place and time to consider these ratios for all of the mixed use districts. So sooner than later.
Okay, thank you. Mr. Pruski.
Thank you, Madam Chair. I just want to reiterate something because there's been a lot of information discussion thrown out there that this bill does not change the threshold for adequate facilities for schools. That is a large issue in my community and other areas, and I want to make absolutely clear, and somebody could answer that from the administration, so we're clear on this, that the threshold for adequate facilities for schools would still have to be met. If we could just please reiterate that for the record. Thank you.
Pete Barron with the administration and Mr. Kai-Ziegler, Ms. Rhodes, please feel free to jump in. That is correct, Councilman Pruski. This bill does not change any rules around adequate public facilities. So for schools, roads, etc.
Mr. Volkey.
Thank you, Madam Chair. Nathan Volkey, District 3. Mr. Kai Ziegler, or maybe Ms. Rhodes, depending, what are the school APF requirements right now for workforce housing?
Ms. Rhodes, are you? It's my understanding, Councilman Volkey, that they would be the same as for traditional residential development, correct, Ms. Rhodes?
That is correct. They would be subject to the subdivision and development code adequacy of public facilities ordinance.
Madam
Okay,
Chair,
thank you.
as a sponsor of the bill, may I add that Councilman Volkey, if you look to section 18-10-162, that's where the conditions for workforce housing are listed, and none of them contain any exemptions from any adequate public facilities tests.
Thank you. Appreciate that, Councilwoman or Vice Chair Lacey. If I may, Madam Chair.
Mr. Volkey.
Thank you, Nathan Volkey, District 3 again. Mr. Kai Ziegler, I guess the one thing that you'd said that was sort of, I was listening and it caused me to kind of jump in, was this idea of these large scale text amendments that you're going to be bringing down in conjunction with the GDP. My question to you would be, if that's the case and you're already planning that and that's the appropriate time to do it is when we're running through the GDP, why is it appropriate to bring in a change like this at this point? I realize this is not a large scale text change and I'm not trying to categorize it as such, but I am curious why it's appropriate at this point as opposed to waiting when you're bringing those other changes sort of holistically. And I recognize also that this is not an administration bill. This is Councilwoman or Vice Chair Lacey's bill. But I guess you all are in support of it. And so that's why I'm asking you that question.
Sure. Steve Kai Ziegler, Planning and Zoning Officer. Again, a very fair question. We have a number of items. There's a lot of cleanup housekeeping that needs to occur with the zoning and subdivision codes. We need to bring that forward sooner than later. Our perspective is our larger scale text amendment should come after GDP so as not to kind of rough up the works in terms of the council's time that you'll need to spend on the GDP. And I think, Councilman Volkey, I think you answered the question is that the bill is from a council person. So as we do with any of those initiatives, we review. Sometimes we can't support the bill. Other times, and this is a particular one that we think we can support. It has relatively limited impacts in the sense that it affects only one of the MXD districts. We've had considerable time to evaluate it, and whether it comes now or in the form of a broader amendment package, the fact is it is in front of us. So we're dealing with what we've been asked to look at.
Thank you.
Ms. Hare.
Thank you, Madam Chair. Jessica Hare, District 7. Ms. Rhodes or Mr. Kai Ziegler, what happens in the event, because of the way the bill is written, it talks about how an applicant can amend its package or change its submission to you. What happens if schools have been vested and after the vesting, an applicant decides to change its application to workforce housing? Will they get kicked out and have to go back through the school APF again? How does that work?
So Steve Kai Ziegler, Planning and Zoning Officer, depending on the type of application, remember they're always different. They're in multiple phases. But if midstream an applicant chooses to or wants to opt out of his office requirement and come in with workforce housing, they also will be looking at the school utilization chart to see if it works for their project. So the fact that the use is changing will require another APF test for schools and roads and other things. So if the school district is open now, but it's going to be closed in 3 months, it's probably not an avenue the applicant would want to change up their project on.
Okay, thank you.
Any other questions or comments from my colleagues regarding Bill 65-20?
Madam Chair.
Ms. Rodbian.
Thank you, Madam Chair. Lisa Radvan, District 6. I really just want to express my appreciation to the sponsor. I think that this is really just making some small adjustments to the MXDR zone, and it really just reflects the times. You know, we're in need of less office space. We're in need of a lot of workforce housing, and this facilitates both of those things and probably makes the development of those things easier. And that's, I think, the direction that we want to be moving. High density, smart growth, facilitating possible future public transportation, utilizing existing public transportation. So I just think this is a all around win.
Any other questions? Ms. Fiedler.
Thank you, Madam Chair. Amanda Fiedler, District 5. Would this be the appropriate time to make comment before voting?
Sure.
You can make comments at any time. Usually we try to do them during public hearings. So yes.
Okay, thank you. And I Amanda Fiedler, District 5, I appreciate the conversation, and Councilman Volke brought up something that has concerned me, and the reason that I won't be voting in favor of this bill this evening. I just have concerns that while I understand the intention of Madam Vice Chair with this piece of legislation, I do think it's, as I said, putting the cart before the horse, and I'm uncomfortable with the idea that we can change course midstream. That's my personal position on this, and the reason I will be voting against the bill this evening.
So just a reminder to my colleagues, we've not had public hearing, but Ms. Hare, you have the floor.
That's okay, I can wait.
Okay. We will now open the public hearing on bill number 65-20. Madam Secretary, do we have any testimony received from the members of the public?
Yes, Madam Chair, we have had 17 submissions of written testimony, which was shared with the council and posted on the county website.
Thank you. We will now hear from members of the public who signed up ahead of time. We have 4 people signed up to speak on this bill. Remarks will be limited to 2 minutes. When it is your turn, please unmute yourself and begin by stating your name and address for the record. We will begin with Austin Holly.
Hello, I hope you can hear me.
We can, Mr. Holly. State your name and address for the record.
Sure. My name is Austin Holly, 315 Locust Thorn Court, Millersville, and I represent the 1,137 homes comprising the Shipley's Choice Homeowners Association and the Shipley's Choice Community Association. I welcome the opportunity to speak tonight. Our associations oppose this legislation. We believe this bill is merely the opposite side of the same old overdevelopment coin, particularly at the land parcels surrounding Veterans Highway and Benfield Boulevard, most of which is forested floodplain for the Severn River headwaters and designated as open space in Plan 2040. Obscure legislation like this, outside the broadly disseminated public zoning process, is no better than spot zoning, which is the exploitation of one-off zoning exceptions for the benefit of specific landowners, and which County Executive Pittman has expressly opposed. However, bills such as this result in exactly the same thing, whereby a few well-connected, overreaching individuals armed with arcane regulations, and in this instance, taxpayer-funded attorneys, get to tell citizens what their way of life should look like, all under the guise of a supposedly public plan. Furthermore, if workforce housing can be entirely substituted for office space, then added to the residential component, what then exactly is mixed use about that? We believe our government is showing us land use maps, such as those within the ongoing Plan 2040 process, in an effort to lull county citizens into complacency, believing our opinions are in fact being heard regarding the future way of life in our county. At the same time, this council passes arcane, incomprehensible legislation that is permanently locking policies into the code without truly seeking or reflecting public opinion. Even as I listen to comments tonight, our own administration representatives are, respectfully, having trouble explaining or justifying this legislation. We urge the council to rely on the public general rezoning process currently underway via Plan 2040 and withdraw this bill. Thank you.
Thank you, sir. We will move on to our second speaker this evening, Miss Amy Leahy. Miss Leahy, are you with us this evening? I don't hear Miss Lacey, Miss Leahy, excuse me. We'll move on to our speaker number 3, Miss Holly Slack. Miss Slack, are you with us this evening?
I am. Can you hear me?
Yes, ma'am. Please state your name and address for the record, and you have 2 minutes.
Thank you. My name is Holly Slack. I am at 438 Bendale Drive in Severna Park, Maryland. I am asking you to vote against this bill 6520. Requirements for maximum residential densities, maximum floor area ratios, and maximum building height are there for a reason. Zoning designations were created with public input, but all these exemptions beginning last year with Bill 5419 have made our input irrelevant. It is detrimental to us and the county to create these constant loopholes. Thank you for letting me share.
Thank you, Ms. Slack. Our 4th speaker on this bill is Mr. Greg Cantori. Are you with us, Mr. Cantori?
Yes, I am. Can you hear me okay?
I can. Please state your name
Great.
and address for the record. You have 2 minutes.
I'm Greg Cantori. I live at 105 Eastern Avenue in Annapolis, Maryland. And just wanted to make a point that all of us, including us sitting here right now, are blurring that space between work and home. And it's something that is our new normal. And I think that mixed use offers us some wonderful opportunities to explore ways in which that new normal can become our exciting future. And I just see this as an opportunity to both provide attainable housing versus the form affordable housing. I have a background in housing development myself, and attainable housing, such as workforce housing, is so much needed in our county. And this is an exciting way to do that. And I wanted to bring up a quick example of how, I know change is difficult. And I was president of Bike Maryland, and we worked hard on the B&A trail, which is now is considered an incredible amenity. It went from an incredible amenity to an essential amenity during COVID. The trail is crowded by people who do want to use that because they know it's important for their health and well-being. But I want to bring you back to when it was first proposed. There was a tremendous opposition from the residents alongside that trail. They were worried about all kinds of things that did not really transpire. And one of the things, of course, was things like property values and traffic and things like that. One of the things that surprised everyone was the property values part. Property values along trails always increase, usually between 2 to 4% higher than the ones that are not right adjacent to the trail. And I'm just bringing this up as a point, is that with workforce housing, we basically have changed the overall use of a property to a positive extent that may not be evident right this moment, but where 10 or 20 years from now, we may look back and realize we did something very smart. That's why it's called smart growth. Thanks.
Thank you, Mr. Cantori. Thank you so much. I'm going to go back to our speaker number 2 to see if she is with us. One last call, Miss Amy Leahy. Okay, I don't believe she joined us this evening. So the public hearing on bill number 6520 is now closed. Madam Secretary, please read the title of bill number 6520.
Bill number 6520, an ordinance concerning zoning, mixed-use districts, workforce housing.
Is there any further discussion on bill 65-20? Ms. Hare.
Thank you, Madam Chair. I just wanted to explain my vote really quickly. Given the comments from Mr. Kai Ziegler about the upcoming potential for larger scale text amendments, particularly which may impact some of these mixed district zones, and that we are going through the general development plan, the fact that this legislation does have the potential to affect at least one property on the Route 3 corridor where I mean, the number of comments I've had from constituents about the amount of high density and intensive use that's gone on there and how we need to pull that back. And then from what I see, the bulk regulations that would apply to the residential piece, if there were no workforce housing, would be in R7 or 7 units per acre. And we're essentially tripling that with the R22 regulations that would be applicable for workforce housing if it replaces the office piece. All those together, I would like to wait and see how this goes forward in the general development plan and really take a larger approach to it as we go. So for those reasons, I'll be voting no at this time.
Thank you. This is Allison Pickard, Chair, District 2. And I wanted to respond a little bit to one of our constituents that the public that spoke just now during the public hearing in regards to a property that's not in my district, but close, the Veterans Highway, Benfield Road parcel that currently has 1.66 acres designated. It's currently undeveloped as mixed R. So with 1.66 acres in mixed R, I wanted to ask Ms. Rhodes one more time, with the fact that it would need to be still mixed use, it could be residential, but it would need to have residential service retail. You could back out the 10 to 25% or whatever that's office. 1.66 acres is not going to get you much of anything. And certainly workforce housing is probably 100% not financially viable when you only have 1.66 acres. It would require structured parking. That in itself would make it not economically viable, but I'm not a developer. I think with so few mixed use R parcels in the community, I think some of the public opposition is a little overblown when you actually get down to what could actually occur on one of these parcels. But I wanted to ask, I wanted to be reminded again of what can currently happen as far as residential development in mixed DR or whatever we call it. Ms. Rhodes?
Lori Rhodes. Yes, 1.66 acres pretty much would get you probably, depending on, an MXD would not get you much, if anything, when you have to combine the mixes and put in the roads, etc. Again, the mixed use R requires 50 to 80%, or it allows 50 to 80% residential, 5 to 25% retail, 0 to 25% office if this bill passes. I mean, that's what is required to be the components under the category of use for mixed use R.
So this is Allison Pickard, Chair D2. So that parcel, again, that is currently almost completely developed, except for that 1.66 acres. I want to make sure I understand. That parcel would does it have to have at least 50% residential, or could it has to have a residential component to be developed, plus a little service retail office at this point without this bill?
Lori Rhodes, again, I would think that property would not be viable for a mixed use development given its size. I mean, that's my opinion. To meet the mixed use requirements.
Yeah. So the 1.66 acres, I just want to be clear for the constituents listening at home and took their time to pay attention to this conversation. I think it's important because there was a lot of concern about the environmental impacts surrounding the watershed there, and it's surrounded by open space, 3.26 acres of open space, and then the last parcel of that that area is 1.66 acres of mixed R. And I think they can be rest assured that workforce housing isn't coming to that corner with or without this bill. Therefore, I will be supporting Bill 6520. Are there any other questions or comments before we call the question? Ms. Lacey.
Thank you, Madam Chair. Sarah Lacey, District 1. I just wanted to point out one philosophical element that I think is relevant to our policy, excuse you, which is that here, on some of the other things that this council has addressed with urgency, that have been very important to some of my colleagues, like farm breweries. I mean, we've done those outside of the GDP process, even though since we're all elected in 2018, we've known that the GDP was going to be a huge part of what we would eventually be working on, but we haven't doctrinally said, because of the GDP, I will not advance this or that specific land use item that my constituents need, want, have asked me to do, to put in a bill. And I think this is sort of indistinguishable from those other efforts in that way, except perhaps that those other efforts related to businesses or what could be viewed as entertainment venues or other parts that are more easily viewed as contributing positively to our economy. But clearly, the folks living in workforce housing in this county are contributing positively to our economy in one way or another. And prior to this GDP and going forward in this GDP, we will still have the same policy goal of increasing the supply or the stock of affordable housing in this county. And specifically, workforce housing will be a piece of that. So I really don't understand the argument that we should wait until the GDP. I also think another way of looking at it, because I'm very pragmatic, is that if I'm crossing a stream and my horse dies in the middle of the stream, I'm getting myself another horse and I am going across that stream to finish what I'm doing. And I think that's what happened here. Office was the horse that died. We can do something smarter, more flexible, more forward thinking, and allow the developers to do that in these small parcels, not parcels, but relatively small sizes of districts that we have. And that'll also be part of the ongoing conversation of how do we make Anne Arundel County the best place for all. And that's what I see this bill as part of doing.
Is there any further comment or questions regarding Bill 65-20 at this time? Seeing
Madam
none.
Chair.
Mr.
Madam
Volpe.
Chair. Thank you. I'll try to be as quick as I possibly can on this. I think, Ms. Rhodes, I believe it was you that said that there were 182 acres, 32 parcels, 3 projects. Is that right? That would be affected by
Lori
this bill?
Rhodes.
Sorry. Yep.
Those are the parcels that GIS provided to me. Whether or not they would be affected by this bill, I cannot answer because the sizes of those parcels range from 0.33 up to, I believe, 29 acres.
Okay, that was going to be my follow-up question was, are we talking about a bunch of tiny little parcels all over the county, or are we talking about primarily large parcels that are in a few places? I mean, 182 acres over 32 parcels, I just am trying to figure out, are there a lot of small ones and one big one, or what are we talking about? I see one, sorry, go ahead. Yep.
I'm sorry, Lori Rhodes, there's several small parcels. I mean, I can send you the list. I mean, it ranges from 0.33 to, I believe it goes up to 29. And combined with all of those small, it came up to about 182 acres.
Okay. All right, thank you.
Ms. Fiedler.
Thank you, Madam Chair. Amanda Fiedler, District 5. I just want to reply to the comment from Madam Vice Chair. And, I know we respectfully have a disagreement here, just like we did in the mentioned farm brewery bill that you did vote against back a year ago. So hopefully you'll extend me that same understanding in my vote this evening.
I see no more flags up from my colleagues. Madam Secretary, please call the roll on bill number 65-20.
Ms. Fiedler,
Nay.
Ms. Rodvian,
Aye.
Ms. Hare,
Nay.
Ms. Lacy,
For the record, I voted against your farm brewery bill for different reasons than the reasons here that were related to a little bit of farming still left in my district. And I just wanted to explain that so everyone would know. And of course, I vote aye on my bill.
Mr. Volkey,
Aye.
Mr. Pruski,
Aye.
Ms. Pickard.
Aye.
5 in the affirmative, 2 in the negative. Bill number 6520 is passed.
Madam Secretary, please read the title of Resolution 33-20.
Resolution 3320, resolution approving the continued service of William Lowry as acting chief of police.
This is an administration resolution. Mr. Barron, you have the floor.
Thank you, Madam Chair. Pete Barron for the administration. Joining me at the virtual table from the Office of Law is Ms. Blair Klausmeyer and our acting chief, Chief Bill Lowry. As per the charter, Resolution 33-20 extends the service of Chief Lowry as acting chief of police until January 21st, 2020. As you will recall from some previous resolutions just like this and some discussion on a charter amendment that will be before the voters. The county executive can appoint a department head for 60 days. After those 60 days, we need to bring a resolution and we can extend for a period of 4 months and then extend one additional time for another 6 months. Chief Lowry has done a fantastic job. He's been a huge resource to me personally on all manner of questions. He is not interested in applying for the permanent spot, so he will remain our acting until we select a permanent chief of police. So with that, we ask you to extend Chief Lowry's term, which he has done honorably and ably as acting chief of police.
Thank you. Mr. Pruski.
Thank you, Madam Chair. As the senior member of the council, I wanted to say a few words. Councilman Pruski, District 4. I don't know if any of you had the opportunity to speak with the acting chief, but I can tell you I've been nothing but impressed. I try and keep in touch with the patrol officers on the road all the way up to lieutenants and even talk to community leaders. And I have to say, in the short time that he's been here, he's very well respected, and I certainly am happy to support this resolution and thank him for his service. He certainly doesn't have to be doing this. I will tell you, he has a long career. I don't know if any of you read his bio or understand where he's been, but he's served Maryland in many different capacities. So again, I just want to go on the record for being involved in the community for over 20 years that I fully respect and am glad to support this resolution this evening. Thank you, Madam Chair.
Any other comments or questions from my colleagues? Allison Pickard, Chair D2. I would like to echo the comments by my colleagues. I had the privilege to be at roll call bright and early one day in Northern District, and I know our patrol officers and leadership in the police force have tremendous respect for you, and I share that respect, and I look forward to supporting this resolution. We will now, seeing no other questions or comments from my colleagues, will now open the public hearing on Resolution 33-20. Madam Secretary, do we have any testimony received from members of the public?
No, Madam Chair, we've had no submissions of written testimony on Resolution 33.
Okay, we did not have any members of the public to sign up to speak. The public hearing on resolution number 33-20 is now closed. Madam Secretary, please read the title of resolution number 33-20.
Resolution number 33-20. Resolution approving the continued service of William Lowry as acting chief of police.
Last call for conversation or questions. Seeing none, Madam Secretary, please call the roll on resolution number 33-20.
Ms. Fiedler?
Aye.
Ms. Rodvian?
Aye.
Ms. Hare?
Aye.
Ms. Lacy?
Aye.
Mr. Volkey?
Aye.
Mr. Pruski?
Aye.
Ms. Pickard?
Aye.
7 in the affirmative, none in the negative. Resolution number 3320 is adopted.
Chief Lowry, you're stuck with us a little longer. Thank you for your service. Madam Secretary, please read the title of resolution number 34-20.
Resolution number 3420. Resolution authorizing the submittal of an application for community development block grant funds and recognizing the county executive's authority to act in connection with the grant.
Thank you. This is an administration resolution. Mr. Barron, you have the floor.
Thank you, Madam Chair. Pete Barron with the administration. Joining me at the virtual table is Ms. Kathy Koch from ACDS, and sticking around is Ms. Blair Klausmeyer from Office of Law. Resolution 34-20 provides evidence of support from the County Council for the county's grant application to the Maryland Department of Housing and Community Development for the Community Development Block Grant funds being made available through the Federal CARES Act to support the county's eviction prevention program. As you are aware, the county was one of the first to stand up an eviction prevention program. It has been very effective and it has been in place since the middle of April. This program has been funded through a variety of sources. These grant dollars, which are being applied for by the county, will enable us to serve more clients during this time of unprecedented need. With me is Ms. Koch, whose agency is lead on the implementation of the eviction prevention program. And I'm going to ask her to just say one or two quick words on this grant application, and then ask you to move it favorably.
Thank you. Madam Chairman, members of the council, Kathy Koch, the Executive Director for the county's Housing and Community Development Agency. As Mr. Barron has said, Resolution 3420 authorizes the submittal of an application to the Maryland Department of Housing and Community Development for community development block grant funds being made available through the CARES Act in the amount of $1.2 million. As he said, we were one of the first ones out of the gate with this program. Since we started the program in mid-April, we have helped over 550 households pay the rent, helping to keep them housed and preventing homelessness during these very trying times. We continue to receive calls every single day, especially as our court systems begin to open. And we have approximately 170 people on a waiting list. These funds will allow us to expand our services and continue to serve people and keep them housed. Here to answer any questions you might have.
Ms. Fiedler.
Thank you, Madam Chair. Amanda Fiedler, D5. I just had a quick question. I went on the state website for the CDBGs, and Anne Arundel County is listed in one of the jurisdictions that is prohibiting from applying under that grant program. There has to be obviously a reason why we can here and now with this. Can you just explain how that all kind of works out?
Yeah, there's lots of different, Kathy Koch, Arundel Community Development Services. Yes, there are lots of different pots of funds that are being available from DHCD, Department of Housing and Community Development. Round one was, if we look at just the block grant dollars that came through the CARES Act to the state, there was 4.5 in round one, and that was for non-entitlement jurisdictions, which we are an entitlement jurisdiction, so we were not eligible to apply in round one. Round two is making $16.2 million available for entitlement jurisdictions. And there's just been announced a round 3, and we're waiting to hear from DHCD on whether round 3 will be made part of the dollars available to entitlement jurisdictions.
Thank you.
Any further questions or comments regarding resolution 34-20? Seeing none, we will now open the public hearing on resolution 34-20. Madam Secretary, do we have any testimony received from members of the public?
Yes, Madam Chair, we had one submission of written testimony, which was shared with the council, and it was posted on the county website.
Thank you. We did not have any members of the public sign up to speak. The public hearing on resolution number 34-20 is now closed. Madam Secretary, please read the title of resolution number 34-20.
Resolution number 34-20. Resolution authorizing the submittal of an application for community development block grant funds and recognizing the county executive's authority to act in connection with the grant.
I'll just ask, any further discussion? Seeing none, Madam Secretary, please call the roll on resolution number 34-20.
Ms. Fiedler?
Aye.
Ms. Rodvian?
Aye.
Ms. Hare?
Aye.
Ms. Lacy?
Aye.
Mr. Volkey?
Aye.
Mr. Pruski?
Aye.
Ms. Pickard?
Aye.
7 in the affirmative, none in the negative. Resolution number 34-20 is adopted.
Madam Secretary, please read the title of resolution number 38-20.
Resolution urging the county executive to lift certain indoor restrictions imposed on restaurants and bars in Anne Arundel County.
Thank you, Ms. Fiedler. You are the lead sponsor with Ms. Hare and Mr. Volkey as co-sponsors. You have the floor.
Thank you, Madam Chair. As the public, or most of the public knows, I have served on the COVID recovery work group for a few months now, and I have supported not only the live streaming, but at a minimum, minutes be taken and made public. I believe if members of the council were privy to some of these conversations, they'd understand the ongoing disagreement related to the curfew on bars and restaurants to close indoor services at 10 o'clock. Restaurants and bars are just weeks away from no longer being able to serve outside because of weather. For months, they've been operating at 50% capacity, and that has caused an enormous financial loss. In July, the county executive did add the additional curfew restrictions. This was done at the suggestion of the county health officer because it was said that we would see, in addition to the case surges, we would see that then play out in the hospitals and in our death rates. We have not seen that at all. These businesses have given back to our community, not only in the taxes that they pay, but by providing support to nonprofit organizations, schools, churches, and in our communities. Many of these owners are members of the communities. They're located here. Their business supports their employees, who are also county residents, and their business supports their own families. The restaurant and bar industry have been unfairly restricted in Anne Arundel County more than any other jurisdiction in the state. Our hospitalizations in the county have been flat since June, while we continue to hold these businesses in a detrimental restricted time frame for opening. There is no evidence to date that points that anyone has contracted COVID at a bar or restaurant. I believe that if we are allowing in the next week movie theaters, indoor entertainment, convenience stores, casinos, and bowling alleys to be open past 10 and serve food and beer and wine or any other alcoholic beverages, why are we not allowing this for our restaurants and our bars? I fully support all of those industries being open and operating to the fullest extent. At the end of the day, we aren't preventing anyone in Anne Arundel County from giving their business to a restaurant or bar after 10 p.m. We are preventing them from doing it in Anne Arundel County. A quick drive to Howard, Baltimore, or Queen Anne's County, depending on where you live, and those businesses will serve our residents, and their businesses will survive while ours are struggling to keep their doors open. I ask that my colleagues support their restaurants and bars in their individual districts by supporting this resolution this evening and asking the county executive to please limit this curfew. That's all.
Mr. Barron, would the administration like to weigh in on this resolution?
Thank you, Madam Chair. I asked Mr. Trumbauer, the Director of Policy and Communications, and Dr. Colleen Naraman to join us this evening. They were able to move their schedules around this. So I'm going to turn it over to Mr. Trumbauer, and then I believe Dr. Colleen Naraman has some slides as well, and a little bit to talk on this a bit more. So to you, Mr. Trumbauer.
Thank you, Chris Trumbauer with County Executive Pittman's administration. Thank you, Council. And our position on this resolution is we'd ask the Council to reject it. Of course, it's within your legislative prerogative to pass your opinion on to the executive, but I took a look at the resolution. I do have one small beef with one of the whereas clauses, and the sponsor just described the 10 p.m. closing time as a curfew. And my understanding of a curfew is it's when you force people to go inside, and we're actually not doing that. We're just asking the bars and the restaurants that serve alcohol to no longer do that after 10. People can still go outside, but they don't have to go inside by a certain time. So we call this the closing time rather than a curfew, but I guess it's a matter of semantics in some way. But we would ask the Council to reject this. We put a lot of thought and deliberation into our policy actions. Councilwoman Fiedler is absolutely correct. There's been rigorous discussion in the recovery work group. There's been lots of disagreements in the recovery work group, and that's part of what makes it so valuable, is to hear that diversity of opinion. But the county executive feels very strongly that this action is a compromise. We have been told by the health officer, and he will elaborate, that bars and restaurants are one place where the disease can spread and has spread. And we don't want that to happen, or at least we want to minimize it. And so we put this 10 p.m. closing time into effect as a compromise to keep the bars and restaurants open, to keep people working. We do realize that it is having an impact on some of the bars and restaurants, and we acknowledge that. And we look forward to getting our case rate down further and trying to get those bars back open to the full time. But the one thing I'll leave you with is this is not a unique action. There are a handful, or actually more than that, states around the country that have taken similar action or still have them in place. These aren't all states that you might think. We're talking about Colorado, Mississippi, Rhode Island, the Carolinas. Even Ohio and Kentucky have had early bar closing times. And in fact, just today, Prime Minister Boris Johnson announced that England's pubs and restaurants are going to start closing at 10 p.m. to try and stem their rising case rates in the UK. So we know that this is an emotional subject. We acknowledge that it is having an impact on the restaurant and bar industry. But we think it is a reasonable action. It's a targeted action. It allows us to keep bars and restaurants open up until 10 p.m. And so we'd ask the Council to reject this. I'd be happy to answer questions, but I'd like to, at this time, pass it over to Dr. Colleen Naraman, who's going to walk through a couple slides and give his statement.
Thank you, Chairwoman and County Council, for having me here tonight. I'm gonna switch over to a few slides just to share some of our data that we have. So bear with me for 1 second. I want to share today's updated case rate. You've all seen a variation of this before, just based on the date. Today we're at 12, and we've been hovering in that 12 to 13 range case rate for the past few days now. I shared this slide with you last time in terms of our data from COVID Link, which is the state platform for logging contact tracing data, and it shows the locations where we see people who are positive have said they have been. Working outside the home is, of course, number one. Retail shopping is number two. And then indoor and outdoor dining are third and fifth. When you combine them, they would actually be second. just ahead of indoor retail. This is our gathering data, and I just left it in here for completeness. It shows the family gatherings are the number one place. We've talked about our case rate. We've talked about the fact that we took an intervention here in late July. And the one in discussion is the one on bars and restaurants and limiting their indoor seating to be closed after 10. And what we saw is about 2.5 weeks later, that started coming down. So it peaked at around 11 days, around 16 days, it started coming down again. And that's really that was really one of the main interventions. The other was, of course, around malls. Notably, Baltimore City took some actions right around that same time, actually closed bars and restaurants to indoor dining and then to open it up to 25% capacity. And they saw a steeper decrease in their case rate at that time. And so in addition to that closing to indoor dining after 10 p.m., we also increased enforcement to make sure that those businesses, and particularly those liquor licensees, were taking the right actions in terms of masking and distancing. Biggest problem in restaurants, though, is that masking is really not practical because people are eating or drinking, and so between sitting at a table together, being close by, and not being able to wear a mask, it's kind of the ideal setup for COVID transmission. And so one of the things we do when we assess our changes is we assess what's the individual risk of the activity. And certainly the risk of bars and restaurants is fairly high. I'm going to show a little bit of detail around why. But we also have to keep in mind that all changes are connected. So when you increase activity in one area, you increase the risk everywhere because the additional activities then bleed into others. And so there's an increased aggregated risk. And the other piece is that risks multiply. So the more the activities that are open, the more rapidly risk increases. And so this is probably the biggest challenge we have in terms of actions and activities. When we consider them individually, they may not seem like they are that impactful, but in the aggregate, they are. And that's part of, or a large part of, what we're seeing in terms of our case rate and why it continues to go up. Now, specifically when we're talking about bars and restaurants, I wanted to show you a slide on teleworking. And I'm showing you this in particular because service occupations, only about 8% of people can telework. That's not surprising. We know that in the service industry, obviously you have to be there to do the work. There isn't telework for a waiter or bartender or any such type of profession. And then when we look at Anne Arundel County, we see that there are 1,912 retail establishments and 1,152 food service and drinking places. And I bring that up because I mentioned that if we combine indoor and outdoor restaurants, it's actually the second highest location of exposure for people who are positive. So when we look at this, I'm going to skip the first bullet. I'll get to that in a second. We see a slightly higher number of exposures at restaurants and bars compared to retail locations, so 368 versus 361. But there's 1,912 retail stores, only 1,152 restaurants and bars. And so we see that people who were positive in Anne Arundel County are 1.7 times more likely to have been at a bar or restaurant than in retail. And that's amongst those who are positive. At the same time, about a week and a half ago, the CDC came out with a report that showed that people who were positive were 2.4 times more likely to be at a bar or restaurant compared to people who were negative. And I emphasize that difference is because our data is only comparing positive to positive, and even there we are seeing that increased likelihood of being at a bar and restaurant. And so what we find is that bars and restaurants and bars continue to have a significantly higher impact on COVID-19 transmission due to the inability to maintain distancing and mask usage. And that's sort of inherent to the establishment itself. So it's not a violation, it's just how it operates. Particularly at night, the situation is made worse by alcohol consumption, and that we see that increases over the course of the night. I don't think that's particularly surprising or groundbreaking. To say that as the night goes on, alcohol sales are a larger part of the sales of any of these establishments. And it will be difficult to control the case rate as bars and restaurants stay open. This is true not just in our county. This is true in every county in every state. And Mr. Trumbauer noted some of those changes. I'll stop by noting that Dr. Fauci has noted the same thing, that bars and restaurants are some of the biggest drivers of cases, and that as case rates go up, closing them will be a way to control that case rate. Whether we do that or not is a decision, but that is what the public health data is showing. So with that, I will stop the slides, and I'm happy to turn it back to you, Madam Chair.
Ms. Hare.
Thank you, Madam Chair. Dr. Kalyana-Raman, I have a couple of questions for you. The slide that you had with the bar chart that showed places people had been, those are self-reported, right?
That is correct.
Okay, so it's only where people are choosing to disclose that they've actually been. Is that accurate?
That's where, yes, that's where they're disclosing, correct.
Okay. Does the indoor shopping retail include grocery stores?
Includes all types of retail, so yes, that includes grocery stores.
So it does. So, okay, so we have fewer people admitting that they went to a grocery store than we do people admitting that they went to a restaurant?
Yeah, I wouldn't say grocery store specifically. I would say retail because I don't have that. I can't say grocery store.
Sure, but if the retail number as a whole is less than indoor and outdoor dining combined, theoretically, even if all of those retails were grocery stores, there'd be fewer of them.
Sure,
I
yeah.
only say that because it strikes me as a little bit unusual that there would be fewer people going to a grocery store everywhere than there would be going to a restaurant. But okay, that's helpful. And then that bar chart, it's not where people, you're not saying that that's where people actually contracted COVID-19. It's just where they may have been in the previous 14 days or so since they tested positive. Is that right?
Just a point of clarification, it's not that fewer people have been to a grocery store, it's fewer people who are positive report having been to a retail location than a bar or restaurant.
Okay.
But the second point around these are the locations they have been in the past in the 14 days prior.
Okay. But not where they necessarily contracted the disease.
No.
Okay. Do we have any data that shows the number of people who have contracted the disease? Have you been able to trace any data specifically to a restaurant or a bar?
It is very difficult to determine an exact location for a number of reasons. One, because of asymptomatic transmission, it's not always clear where that transmission occurs, and that's why we rely on this type of data to be able to show where were you more often or less often. That's the nature of public health data.
Okay, so it's fair to say you can't confirm or deny or not confirm. I suppose you can't really say one way or the other. It's just where people have been after they've self-reported that they've been within the previous 14 days.
Yes.
Okay. My last question, and this relates to the very last slide you put up in terms of alcohol and going forward through the night. I've seen some jurisdictions where they just say, hey, you can't serve alcohol alone. If you're going to serve alcohol past 10 p.m., you got to serve it with food. So anyone who's sitting down and dining could have a glass of wine with their dinner or whatnot. And that gives the restaurants the ability to still stay open past 10 p.m., but also, put safety protocols in place. What's your thought on that? And if you are okay with that, is that something that I suppose you would consider moving forward?
I will. Yes, all places that are serving alcohol are supposed to serve some food, but I think we all see what happens the later the night goes on, that the proportion of what is consumed becomes greater and greater as alcohol and less as food. That was part of the rationale to end indoors at 10 p.m. is to try to cut off, frankly, that last piece where there's more drinking, which reduces social inhibition, and we see people get closer, and that just makes it more and more likely to transmit.
Okay, but I guess my question is, if even after 10 p.m. the restriction stayed in place where you have to be serving food with alcohol, wouldn't that address the concern that we're drinking more and more alcohol without food, and people are, if you're sitting at a table dining, if I go out to dinner with my husband and we're sitting at a table it's 10 p.m. and I'd like to have a glass of wine and order, I don't know, apple pie, whatever it might be. That seems no different than my ordering dinner at 9 p.m. with a glass of wine. And so I'm just trying to, I see an arbitrary demarcation line at 10 p.m. And what it sounds like is your concern is really the bar crowd at midnight or 1 a.m. with no food. Isn't there a way to release the restriction on 10 p.m. while making sure that people are still eating while they're drinking and solve both problems of giving our restaurant owners and our employees of the restaurants the chance to, earn a living, especially as we get into the colder months, while addressing your concern about the alcohol piece?
My concern is actually bars and restaurants in their entirety. There's no distinction made in the time of when these exposures were occurring. Um, so there's some attempt, the 10 p.m. is an attempt to allow some activity while trying to address some of that even higher risk within a high risk category. I think the best way to think about after 10 p.m. indoors is that you have a high risk activity of bars and restaurants, and within that there is an even higher risk segment. And that was the part we were trying to get at. But I think the issue we have from a public health standpoint is that it's inherently at a higher risk than a lot of other activities.
More so than the casinos doing the same thing?
Based on the data we see, yes. So the data we see is really not showing the casinos come up. I will share with you that I thought before the casinos opened that they would be much higher risk, and they have not shown that.
But again, you're relying on self-reported data for that information.
Yes.
Okay.
Ms. Lacey.
Thank you, Madam Chair. Just two quick questions for Dr. Kalyan Raman, and this is Sarah Lacey, District 1. Dr. K, is there any way it would be feasible to get a higher number of either units like hand sanitizing stations or hand washing stations in bars and restaurants generally in Anne Arundel County? It's one of the things that I noticed when I toured the live casino with the specific measures they put in place. They have hand sanitizers everywhere, and we went through their entire protocol of how they clean anything that people might be touching. And so I wonder, because I think up until this point, we've talked about hand washing being the most effective thing you could do to prevent the spread of COVID-19, and then the mask wearing. And so, can we support our restaurants and bars in a way that would help stop the spread of the disease? That's my first question.
Nilesh Kalyanaraman, Health Department. While hand washing is certainly important, I think the issue with restaurants and bars is that people are not wearing masks and they can't distance as a core part of the activity. And unfortunately, while hand hygiene is important, it wouldn't address those particular issues that we're having. So I don't know that would help in that situation in any appreciable way.
Okay, thank you. And my second question is, can the health department perhaps have restaurants and bars, if they were permitted to be open beyond 10 p.m., to have pretty significant warning signs on the doors? People should be warned and educated more than the little signs that are on their doors now, saying what a high risk activity it is that they're undertaking them, and reminding them about saying, and please do tell us if you get sick and you were at this restaurant. Can we do more to educate the public in that way at the point where we're concerned there's a high risk?
Nilesh Kalyanaraman. We could do that, but I don't think that it would be sufficient to mitigate the fact that the activity itself, unless it deterred somebody from undertaking that activity, the activity itself of being in the bar and restaurant is the danger.
Ms. Fiedler.
Thank you, Madam Chair. I want to thank Councilwoman Lacey for asking those questions because I have thought of them myself. When we look at the positivity and the cases, we are still kind of in the same range that we were when, as far as cases are concerned, when the 10 p.m. closure of indoor restaurants and bars was initiated. You know, we did see a drop for a bit, but now the numbers are back up and those businesses are still having to kick customers out at 10 o'clock. I've sent pictures with restaurants that have tables 6 feet apart. Everybody is seated and they have asked me, why do I have to kick all of these good neighborhood customers out at 10 o'clock? Why can't they stay until midnight and finish watching their sports game at their table? So I wonder why we are not trying to create additional signage inside these restaurants and bars to remind patrons that the state requirement is that they are seated to be served, and just be more of a partner and less of a police. I do want to mention at our work session, Mr. Trumbauer stated when presented with information from neighboring jurisdictions that Councilman Volke presented, the response was that those are great and wonderful, but our county has the autonomy to make our own decisions. So I find it interesting that this evening we were comparing ourselves to states across the country and world, really. So back to those risk factor sheets or chart slides. We have established that those slides do not indicate where someone has contracted COVID-19. And in our last meeting, we talked about shifting risk. So my question to you is, are we lowering the risk or are we shifting the risk to somewhere else? Because our numbers are, again, where they were when we initiated this restriction on bars and restaurants. So I'm struggling with why we have to remain in that phase, especially when it's really putting them at in a really bad position.
Nilesh Kalyanaraman. To the question of are we shifting or lowering, it's both. The reality is that any of our actions will be, whether actions or recommendations, will be adopted by a portion of people. Are we lowering the risk? Yes. I think Councilwoman Fiedler, you noted a little earlier, people can go to another jurisdiction. What we find in general is that when we take an action, it lowers the activity overall. And yes, there are some people who shift their activity, but overall, the net result is that we see decreased activity. And that's roughly in line with what we see with all of the actions that we've taken.
We saw decreased activity for about 2 weeks. Sorry, Amanda Fiedler, District 5, for about 2 weeks, and then it returned and has been kind of in the same area since, even with those restrictions. So I don't know if folks who would have dined in Anne Arundel County are now going out of the county, or if they're having folks over to their home instead. But it's just a reminder that these restaurants and bars have been closing for months at 10 p.m. And when the decision was made, said it's because that's the riskiest area. Those are the riskiest, but we're still trending with those closures. So I don't understand. It just doesn't make a whole lot of sense to me. And you mentioned the CDC and showed that slide. And the CDC, from my understanding, got their information based on 11 jurisdictions, I believe. Correct. How do those jurisdictions compare in demographics, size, and COVID response to Anne Arundel County?
So I don't have the answer at my fingertips on how those 11 jurisdictions compare. I'm happy to give you a rundown of that once I take a detailed look at that. But I will say that one of the things that they were able to do as part of that study is they were they were also looking at and talking to people who tested negative, which is not something we're going to do as a part of our regular practice. We wouldn't attempt to contact trace somebody who is negative. That was part of their research protocol, and I think that provides some of the context that I noted, which is that 2.4 times increase was compared to people who tested negative. It's an important piece of data because it's consistent with what we are finding as well. And that's what we're trying to understand. What are the patterns that we're seeing, and to have it corroborated by a study that came out of the CDC simply lends more credence to the data that we're seeing.
Mr. Volke, I just want to warn you that we're at the 90-minute mark for our break for our transcriptionist. Do you have a quick question that we can?
No, let's just break and come back.
Okay. With that, may I have a motion to recess for 10 minutes?
Chair, so moved.
May I have a second?
Rodvian second.
All in favor? Aye.
Aye.
Opposed? The motion carries. The council is recessed for 10 minutes. We will return at 9:21. Looks like we are almost all back. This is Allison Pickard, Chair, District 2. Madam Secretary, it is now 9:21. Please call the roll.
Ms. Fiedler,
Present.
Ms. Rodvian,
Present.
Ms. Hare,
Present.
Ms. Lacey,
Present.
Mr. Volkey,
Present.
Mr. Pruski,
Here.
Ms. Pickard.
Present.
Madam Chair, all council are present.
I believe when we left off, Mr. Volkey, you had a question.
I did. Thank you, Madam Chair. Nathan Volkey, District 3. Doctor, I first want to ask you, are you aware of any other jurisdiction in the state of Maryland that has a 10 p.m. closing time for bars and restaurants?
Nilesh Kalyanaraman. I'm not aware. No. Mr. Trumbauer may be, though.
All right. And Doctor, in terms of the data that you've been using to make these decisions, you have no data that actually shows after 10 p.m. transmission rates in bars or restaurants go up, do you?
Nilesh Kalyanaraman. No, I don't have direct data after 10 p.m.
And I'm looking at the state's COVID dashboard, the 7-day moving average case rate per 100,000 per by jurisdiction, because as we've already talked about, that's the metric that the county is using now instead of positivity rate. As of the data available yesterday, of the big 7 counties in in Maryland, which includes Anne Arundel, Baltimore County, Baltimore City, Harford County, Howard County, Montgomery County, and Prince George's County, of those, only Prince George's County has a higher per 100,000 case rate than Anne Arundel County. Are you aware of that?
Yes, I am.
Okay. And as far as I understand it, Baltimore County, Harford County, and Howard County have all moved to stage 3 of the governor's reopening plan. Is that your understanding as well?
That is my understanding.
All right. And in terms of the efforts that we're making here in this county to try to keep that case rate lower, you in conjunction with the county executive have made some decisions that have frankly kept Anne Arundel County in stage 2, and in some ways have modified it even more than a full open stage 2 with things like this 10 p.m. curfew. Is that right?
I have certainly advised the county executive on these decisions, yes.
Okay. He ultimately makes the decisions, but you've advised him, right?
Correct.
Okay. What I'm really getting at, Doctor, is it doesn't look like what you all are doing is working, because at this point, the case rates continue to be higher than many of our peer jurisdictions, despite the fact that they've opened and we haven't. So I guess where my struggle comes in is you're suggesting to us that we need to keep this curfew to keep bars and restaurants from serving alcohol after 10 p.m. And yet we've got no data to show that that actually is making a difference. And in fact, the case rates keep going up despite this. Am I understanding the facts correctly?
So in part, what we have is data that shows that opening bars and restaurants increases risk. The fact of the matter is that our changes did lead to decreases when we took them in late July. Did they bring them down below a case rate of 1? No, it did not. It produced the effect that it produced, which is to get our case rate down to 7. Our challenge is that that's what it got us. But then if we don't keep going lower, whatever our community spread is going to multiply upon itself. And so that is what we are seeing. And if we truly want to control the spread, we can do what other states have done, which is to decrease the hours for the bars and restaurants. I think that from my standpoint, from a public health standpoint, when we talk about later than 10 or not, we're talking about the highest risk portion of a high risk activity. But at its core, opening restaurants and bars is a higher risk activity for the transmission of COVID.
I appreciate that, doctor, and I thank you for that information. So you indicated that it's the highest risk portion of a high risk activity. I guess my follow-up question to you on that would be, instead of telling bars and restaurants they had to close at 10 p.m., have you considered allowing them to stay open after 10 p.m., but maybe saying they can't serve alcohol because that seems to be your concern, particularly for the restaurants?
I'd be interested in hearing from the bars and restaurants if that was an option for them that they wanted to consider.
Was that something that you all considered, or that in your work groups up to this point you all have discussed or considered?
I'll tell you that while alcohol is a component of that, the being at a bar and restaurant is also a risk activity. So it decreases some of the risk, but not all of it. I can't tell you if others have considered that or not, though.
Okay. Is that something that you've discussed with the county executive, the possibility of keeping bars and restaurants open after 10, but limiting or stopping the service of alcohol?
I have not, because such a step would increase our risk when we already are seeing case rates go up. And so it isn't an option we would put on the table now as a way to decrease our case rate. It would simply increase it less than opening it with alcohol.
Looking at the point in time where you, the county executive, through your advice and others, made the decision to put this 10 p.m. limitation in place, you noted that the case rate went to around 7 at that point after that action had happened. Where I'm struggling with that is one of the things that you've repeatedly told us is that this is not simply a do this, then that type situation, that there are a conjunction of factors, that there are a lot of different points in there. How is it that you're able to say with confidence that that 7 per 100,000 case rate is directly attributable to the decision that you limit bars and restaurants after 10 p.m.?
I'm not suggesting that it is directly attributable only to that. Just that when we look at the data and we look at the changes that were made at the end of July, which included changes around gathering size and changes around malls, and we see the effect they had, and we look at data that is coming from the CDC, we did not have that at that time, but we do have it now. We see the effect of bars and restaurants. It bolsters the idea that played a large role in our decrease.
The concern that I have, doctor, is this. I'm worried that we're conflating correlation with causation. And that is a struggle for me. This idea that we see two things and they look like they're working in conjunction, but we can't necessarily say that it's the cause, but yet we need to keep this one because, well, that's what's causing it. That's not what we're seeing here. We're not able to pinpoint that. And so I guess if no other jurisdictions are having this imposition of a limit of 10 p.m. imposed, many of those jurisdictions that don't have this limit are seeing their case rate go down, and they're not worried about the alcohol situation after 10. I'm just struggling to understand how this particular limitation is making Anne Arundel County safer. So if you have anything you'd like to add to that, I'm happy to hear it.
So I understand your point about correlation and causation. That is something that we are constantly vigilant for. It's one of the reasons that we talk about risks and probabilities as opposed to this led to that.
Sure.
But we also recognize that in the context of understanding what is causing spread of COVID, precisely because there is asymptomatic spread, what we have are probabilities. But we do have to make decisions. If we say that we can't prove anything because we're not able to precisely say we know this transmission was caused because of this particular action, then we would have no actions to take anymore. And so we are, as we build our body of evidence, we see certain correlations, we see their time points, and we also compare it to others. And I noted specifically some of the Baltimore City data when in late July, when they took similar, actually a more extensive action than ours and saw a decrease. And so our job is to pull together these strands of data and try to understand, is there a pattern there? And then to acknowledge when there is a pattern. And what we are seeing is that it does look to be a causation between taking an action in restricting bars and restaurants to whatever extent is taken and a decrease in case rate.
So where I just want to understand this fully then is you were asked earlier about casinos and the continued service of alcohol after 10 p.m. in casinos. I'm unclear as to how a person sitting in a casino at a slot machine, for instance, or at a table game who's being served alcohol is entirely different from someone sitting in a bar drinking alcohol, particularly if the bar has been forced to, well, I'm not going to use the word forced, but has been undertaking social distancing measures, for instance, every other chair or putting 6 feet between patrons or different things like that. How are they different? How is it that in the casino, one can sit there for hours, drink and play a game and potentially talk to the person at the slot machine next to them, but somehow when we're sitting in a bar, it's now different?
So there's two pieces to the no ash kalyan ramen. There are two pieces to this. One is that casinos are regulated in a different way than bars and restaurants, and we had to deal with that initially. There aren't as many dining options within a casino compared to the rest of the county as a whole. I'm certainly open to restricting the hours of restaurants and bars in a casino if that's something that the council would like to explore, because that's certainly another potential mode of transmission as well. But right now, given the numbers that we're seeing in the casinos, we haven't honed in on that as a significant source of spread.
Right. And so considering that you haven't seen that in casinos and considering that the same activity is happening in bars after 10 p.m., and considering that you haven't had bars open past 10 p.m. since March, so you wouldn't actually know what the data would be, how is it that we can say with any degree of certainty that we're doing something impactful by keeping bars closed after 10 p.m.? Seems to me like the data actually from the casinos using the comparable sort of comparing like things to like things suggests that you should be able to open up bars and restaurants after 10 p.m. and not see a significant spike, just as you've not seen it with the casinos.
There are far more restaurants and bars than there are casinos. I mean, I think that when we say casinos and we say restaurants and bars, we should recognize that there's huge disparity in the number between those two. And so to note casinos is to note that we have a few restaurants that we're talking about at the end of the day. And so frankly, from a numbers standpoint, I'm not surprised. It wouldn't register because of the size discrepancy.
Mr. Trumbauer has had his hand up.
Thank you, Madam Chair. Chris Trumbauer with the County Exec's office. Councilman Volke and all of you have asked excellent questions, and I think you are asking the same questions that we all ask ourselves in the County Exec's administration to try and figure out what is the right course of action. And so you've demonstrated that it's not easy, and there are a lot of inconsistencies. But what we're trying to do is take the advice of public health officials and make the best decisions we can. There's no perfect answer. There's no easy answer. And we struggle with all these same questions that Councilman Volke, you are asking, and Councilman Fiedler, you are asking. But the one thing I couldn't help notice about the casino question, and let me preface this by saying I'm not a gambler. I don't go in casinos, but I've seen a lot of movies about them. And what I've noticed about the movies about casinos, they have a lot of staff walking around. They have a lot of cameras on them. I mean, they're very regulated environments, right? And so your neighborhood bar or restaurant, your mom and pop shop and all those things, they don't have the same level of oversight and regulation. I can tell you, we were very reluctant and hesitant to open up the casinos, but they put forth a plan. They met with our health officials, and they demonstrated between their staff, their plan, their precautions, everything that they've done, that they had a rock solid plan in place. Now, you're right. Restaurants and the casino can seem similar, But as Dr. Kalyunaraman said, there's a lot of different restaurants and bars in the county. They're variable, they're different. There's one casino in the county. So I just wanted to point out that we had that struggle. We did discuss it, and I do believe that the casino operations are different than a typical bar or restaurant operation.
Ms. Fiedler.
Thank you, Madam Chair. I want to go back to those data sets and saying that when the action was taken to close restaurants and bars for indoor service at 10 p.m., there was a 2-week trend after that, downtrend. It has been 8 weeks total since those actions were taken, and only in those 2 weeks did we see that downtrend. So I still struggle to see how keeping them closed is doing what was said to have been done. And I just want to remind and my colleagues that this does not, a vote on this resolution this evening does not change the closure of restaurants and bars indoors after 10 p.m. What it does is give our council body a voice for the decisions that the county executive is making. And we all have restaurants and bars in our districts that have been around for very long time and some a very short amount of time. And they are truly struggling. And I think that there's a way to allow them to open their doors again past 10 p.m. and make an even small attempt to survive. And that is what this resolution is saying. It is saying, figure it out how you're going to do it, but this is the will of the council. And that's why I ask for your favorable support, and I'm more than happy to go back to those work group meetings and get the county executive and our health officer to a place where we have agreed on ways that we can help our restaurants and bars implement safety precautions that maybe they didn't think of in early July. And now they're ready and willing and wanting and begging to do that.
This is Allison Pickard, Chair, District 2. This is an intense conversation. I know in my community and my zip codes, I've got about 26% of all the positive cases. So I'm paying attention to all the various restrictions and openings, and I'm a little concerned that we keep talking about this 2-week decrease after we made the 10 o'clock closure time in July, but we've also, I don't have it all memorized as to what started happening since then, but I feel like we've also opened a lot of things, whether it's youth sports or there's been other things that have been released, and maybe we can talk a little bit about that. I'm very concerned that our case rate numbers are not going in the direction of getting our schools opened. So I'm concerned about, I don't know what the right answer is, I can guarantee you, but I'm concerned that our case rates are not going in the right direction, and we're seeing these spikes, whether it's in the UK or European countries, that are going back to lockdown, complete lockdown. And I don't know how we get out of this if we just lift everything again, or if we decide it's over and let's hope for the best, or people aren't dying at the rate they were in March, so it's okay. I don't have the answer of what the right formula is of restrictions, but I am concerned that our case rates are not going in the right direction to be having conversation about loosening our current restrictions. Dr. Kalyana, if these keep going in the wrong direction, from the public health perspective, do you see us needing to go backwards with restrictions?
Nilesh Kalyana. I think we are in particularly when we talk about schools reopening, we are in a very tenuous situation, and I'll speak more about that. I know there's a resolution about that as well. I think one thing maybe that will help explain what we're seeing is, and forgive me, this is the best analogy I can come up with. Um, but if you've ever seen a vert ramp for BMX during the X Games, it pretty much looks like a U, right? Big fat U. And I think the best way to think about COVID and what happens is that we'd really like to be right in the center where it's very flat. Why? Because if you travel an inch, it's still flat. If you travel an inch, it's still flat. If you travel an inch, it's still flat. But at some point, it starts to get steep. And it starts to get steeper faster and faster until you get to the top where it's just pretty much going straight up. If we had a case rate of 0, it would be in the middle. And so if there was another case, if we had a new case, right, it'd be like moving an inch. We wouldn't really notice it in our community. If we did nothing about it, we would see another case, we would move another inch. Our challenge is that we're at a case rate of 7. And so we're right at that part where the vert ramp starts to slope up. And so any movement starts to go really fast. And I think that that's probably the best way to picture what's happening with COVID. And so when we see that our case rate came down from 12 to 7, that got us part of the way down that vert ramp, but it didn't get us all the way. And so now when we're, not now, but back in August when we were to 7, we started moving an inch up and up and up again. And that's our challenge, is that unless we push it all the way down, we're going to keep bouncing around. And it has serious implications, not just for people, but also for school reopening. And that's probably the biggest issue that we're going to see, is it's going to be very difficult to open schools properly, given the case rates that we're at right
now. This is Allison Pickard, Chair D2. Remind me again, I believe the chart that you showed us today showed us that a case rate of 13 was today, not the 7-day average.
Today's 7-day average is actually 12. Okay. It was 13 yesterday, and so we're in that where we've been hanging around 12 to 13 for the past few days.
Okay, thank you. Mr. Volke.
Thank you, Madam Chair. Nathan Volke, District 3. Doctor, I understand the points that you're making, and I appreciate them, as I hear that line a lot from the administration, so I've gotten good at saying it. But with that said, what plan, I heard Mr. Trumbauer mention that the casinos came to the county with a plan. They said, here's what we can do to reopen safely. And Councilwoman Lacey mentioned that she had a chance to go out and tour them and see all of the safety protocols they put in place. What plan can bars or restaurants bring to the county executive that will satisfactorily appease, if you will, the concerns that somehow this highest risk of the high risk category, as you mentioned it, is going to be blunting the edge in some way, that they are going to be able to put some kind of protocol in place that makes you feel comfortable that they are able to be trusted, if you will, and that they are not going to be the center of a spike in COVID-19 cases.
Nilesh Kalyana-Raman. There's 2 pieces to this. One is that we've seen a lot of plans, but the execution and enforcement is really the key to it. But that's a generalized point. The second is that I think the issue with bars and restaurants is that the activity is inherently risky. Even with kind of an optimal setting, still have people who are unmasked and unable to maintain distance as part of the activity itself. And so certainly we encourage and want to see as much fidelity to safety plans as possible, but that's the particular problem we have with this with this sector, is that there's no way to consistently keep masks on while you're eating or drinking. There's no way to be social at a table and to be distant simultaneously. And that's hard, right? And I understand the challenge for bars and restaurants, but as I said before, COVID doesn't really care about our motivations. It simply is looking to transmit itself. And this setting is conducive to transmission.
So, Doctor, I appreciate that. Nathan Volke, District 3, following up. I guess my question would be, I've been to bars and restaurants since March, some of those that have been able to open successfully. Typically, the tables are spaced much farther apart than normal. The wait staff is wearing masks the entire time that they're interacting with you. The folks who are not wearing masks are the patrons at the tables, and they're spaced typically at least 6 feet apart from the other tables. So, what protocols are they not following? And what protocols could they be putting in place that are now going to allow them to be able to satisfy the county that what they're doing is okay, that it's working?
Nilesh Kalyanaraman. One of the while that's certainly, I'm glad that that's what you were seeing. I think the issue we have is that when people are in a group, if they are with people that they are not usually part of, so if they're with somebody who's outside of their pod, then they are mingling with others, right? In a way that they would not have outside of that restaurant setting, or would be able to better keep distance, from them outside of the restaurant setting. And so it's not, I think the challenge here is it isn't that there's a good or a bad actor. It's just that it's an inherently riskier activity. Are there places that are doing it well? Absolutely. Are there places that are not doing it well? Also, unfortunately, absolutely. But overall, it's bringing people together. It's doing the kinds of things that we all want to do. I'd love to go to a restaurant. I haven't been since COVID started. I'd love to go do the things that I used to do. But the reality is that it is a higher risk activity inherently. And while it is absolutely imperative to put in place as many precautions as we can, at its core, it doesn't change that it's a higher risk activity.
Dr. Nathan Volke, District 3, following up again. So I don't want to put words in your mouth, and we did this at the work session the other day where I asked you this kind of question, but from what I'm hearing from you, there is nothing that a bar or a restaurant can put forward in terms of a plan that will make the county satisfied that they are able to stay open past 10 p.m. Is that correct?
Nilesh Kalyanaraman, what I'm saying is that because the activity is inherently at higher risk, any plan can minimize it to that higher risk, but it can't normalize that risk.
So if it can't normalize that higher risk, then at that point, they're not going to be able to open past 10 p.m.
I would not recommend that at this time.
I see. All right. And final question for you, Dr. Nathan Volke, District 3. What case rate would you be looking at per 100,000 that would satisfy you that we could remove this restriction on staying open past 10 p.m.? What's the number you're looking to get to? You said it was 7 is when we put it in place, so that clearly isn't the number. 12 is where we are, 12 to 13. You don't want to take it off now, so that's clearly not the number either. We've talked about a 5 per 100,000 case rate, but that's sort of for opening schools. Where is it we need to get for the bars and restaurants?
Nilesh Kalyanaraman. As we've discussed, it isn't an answer that it can be given in isolation. It has to be given in the context of what else do we want to be open? What are our priorities to be open? If we want schools to open and we want them to be able to be open to all grades, we're going to need to let them open first, and then understand what else can stay open. If we're trying to open everything at once, and I don't mean that facetiously, but just if we're taking each decision independently of each other, then we don't really have a great way of opening schools, because all of these other openings impact our case rate and impact our ability to open schools.
Okay. Thank you, doctor. So it sounds to me like if we're going to open schools and that's the number one target, we got to be below 5. which means we're not going to see bars and restaurants be advised by you to the county executive to stay open past 10 until we at least are below 5. Is that fair?
I think that'd be fair to consider it at that point.
Thank you.
Ms. Hare.
Thank you, Madam Chair. Jessica Hare, District 7. I'm just going to make a brief comment. I'm listening to everyone. I think everyone has had good questions, thoughts. Councilwoman Lacey, I think your point on sort of trying to facilitate additional sanitation measures is well taken. I think that's a great idea for the county to sort of help get there. I think that this resolution is asking the county executive to help facilitate our businesses, the families, the employees and their families who have been in this now for 6 months and trying to survive, and think about the restaurants that aren't able to reopen. And they've all been working very hard to try and get creative with how they do business. But we are getting to a point where it is increasingly difficult. They are struggling in a lot of respects, and they are looking to us to try and facilitate I can't even call it normalcy, but facilitate additional measures so that they can continue to stay open. And so, sure, additional sanitation measures, only serving alcohol with food, whatever it might be. We need to send a message to the county executive that we want to facilitate this piece coming off. Let's find another way to help them stay open, to help them serve our communities. And so that's at least the message that I see in this, and I hope you all will share and support the resolution.
Ms. Rodbian.
Thank you, Madam Chair. Lisa Rodbian, District 6. I actually think we have the same goal, but just very different methods of wanting to reach that goal. I absolutely want everything to return to normal. I want schools to be open again. I want our restaurants and our stores to be open. But I worry that by taking these little measures to, sort of chip away at the protections we put in place, we're actually going to prolong things and make things worse for the businesses. If we end up opening, taking steps towards reopening, well, we should look at what's happening in other places that have done that. We look at the UK, for example. They're about to go or going back into full lockdown because they started making motions towards opening. And so I absolutely think we have the same goal, but I just would like to get there more quickly without having to, have this just be an endless process of open a little, close a little, open a little, close a little. I'd rather just, until we can really see a downward trend, which, I think even on the tack that we have is difficult. We shouldn't be talking about reopening or loosening measures that are in place. I mean, I understand that this is very difficult for businesses. I really do. I feel like my district has been hit pretty hard in terms of, how families have been impacted and, incomes and ability to pay rent and mortgages and all that. But at the same time, the consequences is people die or they get very, very sick. And even people that aren't in the hospital are getting very, very sick. And I think we have to keep that in mind. In my district, things are getting slightly better, but actually in other parts of the county, they're getting worse. I look at the zip code map that is on the aahealth.org page every day, and I think it's really important to look at how things are changing and that some things in the county, some parts of the county are really not at all ready. And we need to move together because what happens in one part of the county affects every part of the county. That's all I have to say. I don't want this to be that I absolutely want us to get back to normal, but I don't think, inviting action or taking action that will invite another spike is helpful at all.
Mr. Trumbauer, you had your hand raised.
Thank you, Madam Chair. Chris Trumbauer with the County Exec's Office. I think Councilwoman Hare made a good point about wanting to encourage the county executive to move forward and allow the bars and restaurants to open. And I mean, we do that all the time. We have those conversations. And I'm going to share a little bit of insider info with between Dr. Nilesh and me. I'm constantly coming up with ideas or making suggestions to him, as all of the county execs cabinets are. And he has a response that I've gotten used to. And it's, I can't think of a public health reason to do that. And that is his job, to give us public health advice. And the reality of the situation is right now, it wasn't that many months ago where everything was shut down, right? State shut everything down. We followed suit. You weren't supposed to leave your house. Seems like a whole lifetime ago. I think it was about 5 months ago. So we've gradually pulled back layers on the state side and also mostly on the county side. And we've enabled things that once we thought were really dangerous. Playgrounds. We thought playgrounds were hotspots, vectors, right? We learned more about the disease. We learned that they're less of a higher risk than we originally thought. We're constantly learning more and making targeted actions to do that. Just today, the county executive signed the executive order allowing theaters and outdoor venues to open up in a limited capacity again, because Dr. Nilesh and his health officials determined that it was less of a risk to do that because that's not where the spread is happening. The reality of the situation is right now, we don't feel comfortable that we're ready to peel that layer back at this moment in time, considering the advice of Dr. Nilesh, where our case rate is, where we're seeing the suggestions from our contact tracing data. We want to get to that point. Maybe it's in a week, maybe it's in 2 weeks, maybe it's in a month. We don't know that. But what Councilwoman Hare said was very appealing. But unfortunately, when I read the resolution that's before you all right now, it doesn't ask to come up with additional measures or safety precautions or work with the businesses. It says allow these businesses to operate past 10 p.m. with their current safety protocols in place. And so the county executive at this moment in time isn't prepared to do that right now based on the advice of the health officials and his consideration of what the data is telling us. But we all want to get there. And so I would encourage the council and anybody to keep coming up with ideas, to keep engaging, to keep engaging the county executive in this conversation to get what we all want, which is a return to normalcy. But I'd ask the council to stick with us a little bit longer, reject this resolution at this time, and hopefully we can see our case rate go down into a level that is no longer causing us the concern of community spread, and that we can open schools and open restaurants and open everything in a controlled and responsible way. Thank you, Madam Chair.
Ms. Fiedler.
Thank you, Madam Chair. Amanda Fiedler, District 5. Mr. Trumbauer, I appreciate those comments, and I just want to reiterate the spirit of this resolution is to ask the county executive to allow restaurants and bars to stay open past 10 p.m. and serve food, stay in business is really what this resolution is asking. I cannot reiterate the communications that I have had from these business owners who have been disproportionately affected by the loss of business. And if a pod wants to get together and they can't get together at a restaurant where you are required to be seated at your table, you are required to wear a mask from the front door to the table, you are required to wear a mask from the table to the restroom. The pods are going to meet in other places, and it's only hurting those businesses. That is all.
Mr. Volkey.
Thank you, Madam Chair. I just want to summarize for my colleagues what I believe I've heard, and maybe others have heard something differently. But what I've heard is we put this into place when our case rates were around 7. At this point, we saw a little bit of a change over the intervening 2 weeks, but now we're up to a case rate of over 12. We're between 12 and 13. We aren't going to be able to open schools until we get to a case rate of 5. We haven't been at a case rate of 5 in this county since basically July the 7th, 2020. The idea that we're going to get to a case rate of 5 at the rate that we're going, I don't know what the projections are, if there's going to be some precipitous drop or not. But I can look at other jurisdictions around us. I don't need to look at the UK. I don't need to look at Italy. I don't need to look at other countries. I certainly can. They're instructive. But I can also look next door in Baltimore County. I can look next door in Howard County. And in both of them, they've moved into stage 3, and they've also seen their rates, which are now lower than ours, go largely in concert with ours. But they've also, seen some dips where we haven't necessarily. So all this data is available in the state if anybody wants to put some cool charts together. My point is this. We all talk about making decisions based on data. We all talk about asking questions of the people who come in front of us and then making a data-based decision. I'm not trying to take anything away from the doctor or the health department or anybody in the administration, but so far the data is not there. There is no data that I've heard of, and Dr. Kalyanaraman made this clear. There's no data that shows after 10 o'clock that this is actually making an impact. We haven't seen it, and we don't have it from anywhere else. So we're sort of looking anecdotally, and we're relying on gut instinct, and we're relying on feel. And to a certain degree, that's expertise, and I get that. To another degree, that's sort of reading tea leaves. So we have to try to figure out where that distinction is. The concern that I have at this point is that in reading that distinction, I'm not hearing enough that makes me say, this makes sense for us to just kind of blindly continue down this path when we're not seeing the desired results from the outcome. And while at the same time, we are seeing significant impacts to our business community who are just absolutely suffering. I mean, I was thinking about this a moment ago. We're not going to need workforce housing if we don't have any restaurants and there's no workforce. And there's not going to be a workforce if there's no businesses. And that's quickly coming if we keep these folks from being able to make a living and earning money. So this is such a complicated issue. I understand it's complicated. None of us on the GOP side of the aisle are trying to advocate and say, oh, this is just really simple, it's easy. It's not. But we're looking at the same impacts and we have the same desires, and I think that's genuinely true. The difference is when we look at the data, we're just not seeing data that backs up these continued restrictions. What we're seeing is a lot of, let's do this. Okay, let's see what happens. Let's do this. Let's see what happens. And generally, at least I've thought, this council has encouraged our own decisions and any decisions others are bringing to us to be data-based. And on this particular part of the restrictions that are in place, we're not seeing the data. So I would hope that all of you can consider that and think about that as we vote. Again, this is a non-binding resolution. This is a statement of intent from the council. So I would just leave it there. Thank you.
Thank you. This is Allison Pickard, District 2 Chair of the Council. We like to talk about Baltimore County and Howard County and the counties that have moved forward to stage 3, but there are 4 jurisdictions in the state that haven't, and they represent over 3 million people in the state of Maryland, which is half of our population. So I want to be clear, we're also not the only people dealing with COVID-19 and all the ramifications and consequences that come with this global pandemic. This is happening in every state and in every country around the world. 4 states and the UK have limited the 10 p.m. closure of restaurants and bars. I don't know what the right formula is to get our case rate down, to get us in better. I don't. So I'm relying on the health expertise, and I'm not in support of this resolution at this time, but I will yield to my colleague, Ms. Fiedler.
Thank you, Madam Chair. I wanted to make sure that I addressed some of the previous comments and some of the language in the resolution. So our Assistant Administrative Officer, Ms. Corby, has put together an amendment to this, which is a technical amendment, but would address those. And Ms. Corby, when you are ready, if you don't mind sharing. So this, I don't know if Madam Secretary would like to read this into record.
Yes, momentarily. I'm making sure I have the correct version.
Point of order, just if Ms. Corby might be able to zoom in, since the text is only on the top part of the page, to make it, is there a way to make it larger?
And I can read it in now, so that should help.
Okay, thank you very much.
And now I can. There we go. Okay, amendment number 1. This amendment changes the word curfew to restriction to reflect the current status and changes the term their current to proper to reflect best practices for safety protocol.
Thank you, Madam Secretary. Madam Chair.
Is there a motion to adopt this amendment?
Chair, so moved.
Is there a second?
Second, Bulky, second.
Ms. Fiedler, did you want to speak to this?
I think it's pretty self-explanatory, Amanda Fiedler, District 5, but this is really in an effort to get the resolution to show good faith on the intent of it, and that I really want the administration and my colleagues to understand that this is in an effort to try to salvage some of our businesses who are really struggling right now. And ultimately, the county executive still makes the final call.
Does the administration want to weigh in on this, or should we move forward with the vote?
Thank you, Madam Chair. Pete Barron for the administration. We're just seeing this resolution. If I may, can I ask a quick clarifying question? As I understand it, you're changing the word curfew to restriction, and it is still calling for bars and restaurants to be open past 10, although you're softening some of the language around the proper restrictions rather than the proper protections rather than the protections they currently have in place. Just trying to make sure I understand it. It's sometimes hard to see an amendment outside of context of the actual bill language.
Madam Chair.
Ms. Fiedler.
Thank you. Amanda Fiedler, District 5. Mr. Barron, you are correct. This amendment addresses the 2 areas that Mr. Trumbauer noted prior.
Thank you. Thank you. At this time, I think the administration is still concerned that we are not able to open bars and restaurants past 10 at this point. Like Mr. Trumbauer said and Dr. Kay said, we want to get there. We're just not there yet.
Madam Chair.
I'll let Mr. Trumbauer add anything.
Mr. Trumbauer.
Thank you, Chris Trumbauer with the County Execs Administration. Yeah, I really appreciate this amendment. I think the 2 concerns that we brought up about the wording, this does fix, so I appreciate them. I've always had a hard time with people referring to the 10 p.m. closing as a curfew, so I appreciate that. And then the way I read this now, I'm a little confused about the intent though, because without saying, before it said open the bars and restaurants or get rid of the 10 p.m. closing time. Now it says get rid of the 10 p.m. closing time if they get proper safety measures in place. So that's more of a future action, or I guess I'm asking to elaborate on the intent to see if it's changed the resolution.
Ms. Fiedler.
Thank you, Madam Chair. That gives the administration the flexibility to work with the health officer and the work group, since you have noted how much work we do in that time frame and positive and needle moving in some circumstances. that language gives the flexibility for the county executive to explore ways to improve safe measures and safeguards in restaurants and bars that may not be required or taking place at this time. Some of the recommendations have been suggested by my colleagues this evening.
Thank you, Councilwoman. So am I correct in saying that the posture has gone from get rid of the 10 p.m. closing time to more of a find a way to get rid of the 10 p.m. closing time?
I would agree with that.
Madam Chair, I don't know what's appropriate, but I would love a minute to discuss with Mr. the administration's position at this point. How do we do that in this virtual world?
Motion to recess, Madam Chair.
5 minutes?
Yeah, but Madam Chair, if I may, is there a version of the amendment incorporated into the resolution? I know.
No, not at the moment. Oh, well, I could be wrong.
That would be very helpful. Thank you. And yes, I didn't mean to interrupt, but I would like to. I agree with Mr. Trumbauer. I'd like a minute or two to discuss.
There's a motion to recess. Is there a second?
Fair, second.
All in favor?
Aye.
Aye.
Aye. Opposed? All right, we will recess. This council's in recess for the next 5, 10, 5?
Take our 10-minute break now.
5-minute recess. We will be back at 10:17. Madam Secretary, please call the roll.
Ms. Fiedler,
Present.
Ms. Rodvian,
Present.
Ms. Hare,
Present.
Ms. Lacy,
Present.
Mr. Volkey, Mr. Volkey, Mr. Volkey, can you hear me? I see Mr. Volkey, but there he is. He's connecting to audio. I'll go back to him. Mr. Pruski?
Present.
Ms. Pickard?
Present.
Mr. He's still connecting. Mr. Volkey, you are present and connected?
I am, yes, thank you, apologies.
Madam Chair, all council members are present.
Thank you. I believe we recessed at the request of the administration, Mr. Trumbauer, Mr. Barron, who would like to speak for the administration.
Thank you, Madam Chair. Pete Barron with the administration. Appreciate the quick opportunity to huddle. I'm gonna turn it over to Mr. Trumbauer to talk about this a little bit more in detail. Thank you.
Thank you, Madam Chair. Chris Trumbauer with the County Exec's Office. We discussed the amendment. We actually do think the amendment makes the resolution better. So we don't have an objection to the amendment, and we'll reserve the right to comment on the full resolution at the appropriate time.
Okay. Any other comments about the amendment number 1? Madam Secretary, please call the roll on amendment number 1.
Ms. Fiedler?
Aye.
Ms. Rodvian?
Aye.
Ms. Hare?
Aye.
Ms. Lacy?
Aye.
Mr. Volkey?
Aye.
Mr. Pruski?
Aye.
Ms. Pickard?
Aye.
7 in the affirmative, none in the negative. Amendment number 1 is adopted.
Is there any further discussion on the amended resolution number 38-20? Mr. Trumbauer.
Thank you, Madam Chair. Chris Trumbauer at the County Exec's Office. So again, thank you for the opportunity to huddle from the admin side a little bit and discuss this. And I think it's important to keep in mind the context of this resolution, that it is a non-binding resolution. It's the council letting the county executive and the administration know of its intent. And we certainly take it that way and view that it is part of a discussion, much like we have our insight from Dr. Akalia Nariman, and we talk to members of the recovery work group. So after huddling, the administration still can't quite support the amendment, but we do appreciate the dialogue, and we appreciate the intent of the sponsors. But we can't at this time commit to knowing for certain that there are deliberate safety precautions or best practices or measures, or even a case rate number or something that will trigger the county executive to recommend or to have the bars and restaurants, open past 10 p.m. Again, it is a goal and objective that we want to get to. We want to get there when the health officer and his public health officials tell us it's safe to do so. We want to continue looking at additional safety measures or situations that can help us get there. But we appreciate the amendment to the resolution, but at this time, the administration still can't support it. So thank you, Madam Chair.
Mr. Volkey.
Thank you, Madam Chair. Nathan Volkey, District 3. Mr. Trumbauer, if I may ask, I'm glad that you all huddled up and had a chance to review this. What was it that made you support the amendment, but that now has you still against the resolution?
Chris Trumbauer at the County Exec's Office. I mean, the amendment made the resolution better, but we still don't agree to it. I mean, just the fact that you took the word curfew out scored some points for us, I think. But also you clarified the intent was not to open right now with the current measures in place, but to try and figure out a way to get there. And like I said at the time, and I think the administration would continue to say, we want to get there too, and we're trying to get there too. It's just that we don't feel comfortable committing to the resolution that's before us at this time. But our objection is very polite.
Ms. Fiedler.
Thank you, Madam Chair. Just in closing, can you confirm, Mr. Trumbauer or Mr. Barron, whoever would like to take this, that if this council passes this resolution this evening, the county executive still has the authority under current powers to remain status quo as far as restaurants and bars closing at 10 p.m.?
Chris Trumbauer at the county exec's office. I think you're asking if this resolution would have any immediate effect on our policy, and the answer would be no. It would of course be the council, if this were to pass, it would be an official way of the council notifying the executive of his intent, and certainly that would be taken into his consideration, but it would not have an immediate practical impact on the policy. I think that's what you're asking.
Yes.
Okay, sorry if that was a bad answer, but it's late. Much better in the morning.
Any further discussion on the amended resolution number 38-20? Seeing none, Madam Secretary, please call the roll on resolution 38-20.
Ms. Fiedler?
Aye.
Ms. Rodvian?
I'd just like to take a minute to explain my vote. I'm going to vote against this resolution. I just don't believe this is the priority that we should be focusing on right now. I'm very comfortable putting matters of public health in our health director and our health department. I think our first priority should be getting our county healthy so we can open schools and then fully open businesses in the long run. So I will vote nay.
Ms. Hare?
Aye.
Ms. Lacy?
Aye.
Mr. Volkey?
Aye.
Mr. Pruski?
Aye.
Ms. Pickard?
Nay.
5 in the affirmative, 2 in the negative. Resolution 38-20 as amended is adopted.
Madam Secretary, please read the title of Resolution 39-20.
Resolution 39-20, resolution requesting the Anne Arundel County Department of Health to formulate guidance to safely reopen elementary schools and special education for in-person learning in accordance with guidance set forth by the State Board of Education.
Ms. Hare is the sponsor. You have the floor.
Thank you, Madam Chair, and I'll try and be brief. I know it's getting late. We had a conversation at the work session, Dr. K, after you gave your presentation. We discussed a little bit about sort of the need for in-person instruction in the special education and elementary schools. And I believe, Dr. K, you had even mentioned that you were working on some guidance for the schools and that you recognize that the special education and a full in-person reopening may be justified at a higher case rate than a high school reopening, et cetera, just given the special circumstances that surround each area of kids. One of the concerns that I've heard from a number of constituents is this sort of ongoing unknown. Nobody knows when things might happen. Nobody knows when the next guidance might be happening. And you had mentioned, I believe, that you were working on this guidance, that it might come out in a handful of weeks. That was, I believe, on the 14th or 15th of the month. I thought it would be helpful for parents and educators and everyone really, myself included, to have a date by which the health department would be providing this guidance, whatever it may be that comes out of your office, to say, here's what we think would be effective, or here's what we'd like to see, whether it's cohort size or whatever it may be that you're putting in this guidance for the special education in the elementary school, specifically to reopen. And so all this resolution does is it asks that you provide that guidance by October 1, which is, I imagine about the same time frame you were probably looking at anyways, but it gives people the ability to sort of count on that date and look for it and know that they have this coming. And I think that even just that would be very helpful for people moving forward and looking for what to expect next. So with that, I hope that everyone can support this. Again, it's not suggesting to the schools that they reopen by October 1 or that they must do anything by October 1. This is just looking for the health department to provide that guidance that's needed within the time frame that I think the health department's probably already working under.
Would the administration like to weigh in on resolution number 39-20?
Thank you, Madam Chair, Pete Barron for for the administration. To speak on the resolution, I have Mr. Trumbauer sticking around with me, and Dr. Colleen Naraman, our health officer, also sticking around for this one. Thank you, Councilwoman Hare, for the resolution. I appreciate the conversation we had in advance of it. As I think Dr. K and Chris can probably speak to a little bit more. The administration is having the conversations and doing the preparation work to be ready around this time. I don't think we will have any issue reaching that date, but I want to ask Dr. K to talk a little bit more about all the work that is going in to getting these plans ready.
Yes, thank you, Nilesh Kalyana. Thank you, Councilwoman Hare. As we were talking about, we're certainly working on this. Our timeline was that we were working on this in July in conversations with the Maryland Department of Health. They made clear that they were going to be coming out with guidelines, and I think we all generally have a preference for state guidelines to provide uniformity, and so we held on our work, waiting for that. And that duly came out right at the end of August. It provided a framework, but not enough detail to actually execute an opening. And so we had to pick up the ball from there. We've been working with a scientific advisory group comprised of members from Johns Hopkins, University of Maryland, Morgan State, to help shape our reopening metrics, to help shape our testing approach and our approach to cases in schools and closures. And I noted that we were a few weeks away. We're on the order of a few days away at this point. Later this week, we're meeting with stakeholders from the educational community, including unions and parent-teacher associations and Board of Education as well, to review where we are, understand their concerns, get their input, and have been working hand in glove with the county public school system. So we're on the order of days, as I noted. I think that probably the biggest issue we're having is that we're having to spend a lot more time figuring out what to do. As you may recall, the state's guidelines were from between a case rate of 5 to 15, and unfortunately, because of where we are in terms of case rate in that 12 to 13 range, we're actually spending a lot of time figuring out if we can even open schools, and if so, what grades at that level, because that's where we are. And what happens above 15 is taking a lot more discussion. Candidly, it doesn't seem like there's a lot we can do in terms of reopening if we're getting above 15 and where we are. So that's taken a bit extra time. But as I mentioned, we are days away.
Ms. Hare.
Thank you, Madam Chair. Jessica Hare, District 7. Dr. K, that's awesome to hear. I'm very excited. If you want to beat October 1, that would be incredible. I think a lot of parents would be very happy to see some of that. Anecdotally, obviously, we've heard about some of the difficulties that parents are having individually, and some of the sort of, I'll call them wraparound services, particularly for some of the kids in the special needs groups, that really this guidance, I think, will be very welcome from those families because they will see it as one step closer. So I'm going to be very excited if you want to beat October 1.
Ms. Radvian.
Thank you, Madam Chair. I actually think Councilman Pruski was ahead of me if he wants to go first.
I will yield.
All right, thank you. This is not mentioned in the resolution, and Dr. Kalyanaraman, you did mention that you'd be speaking with teachers unions, but I would also urge you, let me disclose that I am a part-time employee for Anne Arundel County Public Schools. I'm also a member of our teachers union. I do not, however, teach special education. I do not teach elementary education, but I talk to my colleagues that do. And there are a very wide range of concerns that they have raised with me, or really not specifically with me, but with me and other colleagues, that I would not have thought of as a person who does not work, for example, at Central Special. For example, if you have a student who is nonverbal and maybe experiencing symptoms, they may not have an effective way to communicate it. It may appear that they're just not in a great mood that day. Students in Central Special often take a lot of care for, things that we don't necessarily think of teachers being part of their job, but things like changing diapers, or wiping drool from faces and things like that. That add a special layer. As I'm sure you probably are aware, some of the most medically fragile students are also students in special education programs. So I think, I would urge you to ensure that that the teachers union TAC brings to the table teachers who have those very specific job assignments, who can tell you exactly what their day is like, what kind of things that might need to be addressed. Is it possible for a student to wear a mask? Will it be possible for a teacher to wear a mask where you have a student who might be inclined to grab at things? So I really just urge you to make sure that you look really thoroughly at all of those kinds of concerns, because I haven't heard a whole lot of discussion about that side of it. And I think those are a lot of concerns that need to be addressed. And the same thing with elementary education. I think most of us can probably relate a little bit closer to elementary education, because at one point we were elementary students, and maybe we have elementary students in our homes. So we have a little bit better concept, but still interaction of a group of, 20 to 30 students is not something in most of, 6-year-olds or 7-year-olds or 8-year-olds is not something that most of us do. Even as a teacher, I don't do that. I work with a different age range and their behavior is different. So I would want to make sure that the voices of someone who's very familiar with their group behavior was part of that conversation. So with that, I'll say I do support this this resolution, but I would absolutely urge you to make sure those voices are included.
Mr. Pruski.
Thank you, Madam Chair. Andrew Pruski, Councilman District 4. A lot of the conversation this evening, even regarding other resolutions and the board, relates to what is the best practice and what can be done to stop the spread of COVID. My question to Dr. Kay, and it relates to the resolution, and this is always a concern of mine because I served as a former school board member, is us telling the school board what to do. I want to ask Dr. Kay or the administration to be very clear on this. The Board of Education determines whether schools open, not the county council. And again, I say that because putting in a report, which I may support this resolution or other things, but there may be an inference here that, if it's done by October 1st, schools open October 2nd. And I know there's been a lot of conversations, a lot of stakeholders involved. So I'd ask Dr. Kay and the admin to kind of address, again, if there's inferences being made from this resolution, or is it simply saying that we're going to create a report for October 1st? I just want to be clear to the public, because when some people see that the county council voted to say, hey, we wanted to report by October 1st, we're saying schools, you need to be open October 2nd. So again, I know that's not the intention of the sponsor. I see her shaking her head. I realize that. But Dr. Kay, you've been in conversations with the Board of Education. And so I think if you could clarify publicly where those conversations are at, and also where does the ultimate authority lie? I just make sure that's clear regarding this resolution or anything we do regards to schools. Thank you.
Nilesh Kalyanaraman. So, Councilman Persky, you're correct. Our role in this is to set out the conditions that make school reopening school reopening favorable, and those that are not favorable for school reopening, to provide guidance to the school system to make its decisions. We do not make those decisions for the school system. We are functioning in an advisory role.
Ms. Hare.
Thank you, Madam Chair. Jessica Hare, District 7. I think actually Dr. K just said it much better than even I could. I wanted to just make clear that this is not suggesting that the Board of Ed do anything specific. This is just the advisory sort of position and trying to get people the tools that they need to make those decisions one way or another.
This is Allison Pickard, Chair D2, and I've had the opportunity over the last week to spend some time talking with Board of Education members and just today, Dr. Arlotto, regarding all the decisions going into how and when and if and hybrid and full person, in-person, cat north, cat south. It is a very complicated decision, and I'm a little concerned. I'll piggyback on what Mr. Pruski said, that this resolution is a bit vague. I'm not exactly sure what we're asking the health department to do by October 1st. I do know there are lots and lots of discussions and decision-making panels and work groups and things happening within and related to schools. It's a non-binding resolution. If Dr. Kallarani says he can create some guidelines by October 1st, so be it. But it does get confusing as to what the general public understands is happening. I'm at a loss. It's late, and I don't know. Does anybody have any other comments about this resolution at this time? Seeing none, Madam Secretary, please call the roll on resolution number 39-20.
Ms. Fiedler?
Aye.
Ms. Rodvian?
Aye.
Ms. Hare?
Aye.
Ms. Lacey?
Nay.
Mr. Volkey?
Aye.
Mr. Pruski?
Aye.
Ms. Pickard?
Aye.
6 in the affirmative, 1 in the negative. Resolution number 39-20 is adopted.
Thank you. Is there any other business to be brought before the County Council at this time?
Motion to adjourn, Volkey, District 3.
Is there a second?
Second.
All in favor? Aye.
Aye.
Opposed? The motion carries. The County Council is adjourned until 6 p.m. on October 5th, 2020. Have a great night, everyone, and stay safe.